Weekly list मिलो और overall item 6 मिलो.
Weekly list.
Item 6.
Rajendra Kumar Sahu.
Yes, madam.
All right. Counsel, the petitioner seeks leave to withdraw this petition.
In that matter, I am appearing for opposite matter 2.
All right.
I may be pardoned, my lordship. Item 13 of the supplementary list.
Speak to the mic. Item
13 of the supplementary list. On board. I'm for the opposite party number 4 IOCL, my lordship.
You have to speak into the mic, please. You're not audible.
I'm for the opposite party number 4, my lordship. IOCL, my lordship.
Have you informed the petitioner?
My lordship.
My lord, I'm for the opposite party. I'm for other opposite party, your lordship.
All right. Counsel with IOCL seeks more time to file the convenience compilation. List after 12 weeks.
That county is this.
Supplementary list, fresh admission, item number 1.
May I please, my lord?
Mr. Mahanti, come near to the mic.
May I please, my lord? My lord, the impugned order is at annexure 5, my lord. Running page number 26.
Yes.
My lord, running page number 26. I am reading, my lord. Paragraph 3 is relevant. Peruse the complaint as well as the order of the learned Lokayukta impugned herein, besides having a grave doubt on the locus standi of the petitioner in raking into such dispute. This court also finds the grievance of the petitioner having been taken into account by the learned Lokayukta is well discussed, and order has closed the complaint under the justified reasons. In my lord, I have to satisfy on 2 points, my lord. Here the first, my lord, the first is locus standi, my lord. Here the Honorable Single Judge failed to appreciate the aims and objects of the Lokayukta Act, my lord. That's why I want to take your lordships.
1 minute. Let's get into the facts first. Come to page 25.
25. Yes. 25 is the order of the Lokayukta.
Please read it.
In the present complaint dated 27/1/2021, prayer is made for taking strong legal action against Sri Vijay Kumar Sharma IPS for attending regular law classes in University Law College, Vaniviyar, Bhubaneswar during duty hours for 3 years. Admittedly, Sri Vijay Kumar Sharma attended the law classes after obtaining permission from the government. Even otherwise, attending law classes in university is not a crime. Here, my lord,
Kindly finish reading it.
not only this, we also find the allegations stale and trivial in nature. For these reasons, we are not inclined to entertain the complaint for taking action against Vijay Kumar Sharma, who passed his LLB as per back is in 2014. Here, my lord, I have to.
No, so 2014, the man passed his LLB.
Yes, my lord.
So when did you file the complaint?
It is within the 7 years period, my lord.
There's no question of 7 years period and all. What is this? Why did you wait for 7 years?
No, my lord. Continuously, he is making, my lord, in read petition, my lord will found that all he had making representation before different authorities, my lord.
Mere representation is not going to carry you any forward.
And my lord, when? Yes, my lord. That I want to answer, my lord. Here, the Lokayukta Act is of the year 2014, my lord.
So,
but here the Lokayukta had taken charge in 2 years back only, my lord.
No, there's been a Lokayukta even before this.
Yes, my lord. I have given the date, my lord. Even if the running page number 22 of my writ application, even if Lokayukta Act is of the year 2014, but by notification dated 23/6/2018, the Odisha Lokayukta Act came into force, my lord. Here, since then it is functioning, my lord. Only since 2018, my lord.
So you waited for 3 more years to file your complaint.
That is the reason, my
Why
lord.
chase a man who's done his LLB?
Yes, my lord. If he had permission, I have no case, my lord. Because without obtaining permission, he is continuing his studies, my lord.
Okay.
And he is a senior IPS officer, my lord.
Or you say the court has heard Mr. Shiv Shankar Mohanty, learned counsel for the appellant, and has also perused the impugned order of the single judge. Paragraph. The order of the Lokayukta against which the petitioner filed the writ petition in which the impugned order was passed reads as under. Reproduce the Lokayukta's order, Annexure 5, Annexure 4,
It is 4.
page 25, paragraph. Mr. Mohanty, the counsel for the appellant, states that the Lokayukta in Orissa started functioning only sometime in 2018, and therefore the complaint filed in 2021 should not be viewed as being belated. Secondly, he submits that the presumption that person in question attended LLB classes only after obtaining permission from the government is not correct. Paragraph. The court finds that even though the Lokayukta was functioning since 2018, the complaint itself was filed only in 2021. Further, this was more than 7 years after the person in question passed his LLB exams. In the circumstances, the court is unable to come to a conclusion different from that of the learned single judge, that the order of the Lokayukta does not call for interference. The appeal is dismissed.
My lord, it is within 7 years period, and only one annexure 1 where only I want to press, my lord. Annexure 1 is only for permission of 1 year only.
All right.
Thereafter, the opposite party number 6 has been promoted as the additional DG CPCID.
All right.
His headquarter has been changed, and before leaving headquarter, he had to taking permission from competent authority, my lord.
All right. Okay.
That annexure 1 I have placed, my lord, that may be recorded, my lord.
That's
It is permission for 1 year only.
all right. All right. Okay.
Item number 2.
Item number 2, my lord.
Yes, please.
Right. Lordship would kindly see your lordship's previous order dated 13th of April 2021.
Yes.
So I take your lordship to merits involved here. I think state was supposed to obtain instruction and come back to your lordship, my lord.
Yes, Mr. Monty.
It's, I'm sorry, my lords, that draft has been prepared on the basis of the Paramedics comments received. I pray for a short adjournment.
Mr. Sahu submits that the counter affidavit will be possibly be filed within 4 weeks. Rejoinder is any the next date. List after 8 weeks.
Item number 3.
Listed after 8 weeks.
Item number 3.
Millard, in this case, I am for the petitioner, Millard. Yesterday, I got the counter copy of which has been supplied to me by the state. Millard, I want to file a rejoinder, Millard.
What does the counter say?
Millard, in para 11, they have given some evasive information, Millard. Some false and evasive information in para 11 of their counter. They have.
Counter, Mr. Tripathi, when did you file the counter?
My lord, I am appearing for the state, my lord, Mr. Das.
When did you file the counter, Mr. Das?
My lord, we filed counter on 17th, my lord.
Doesn't come on record. You say the counter affidavit of the state be placed on record. Petitioner is permitted to file a rejoinder within 2 weeks. List after 8 weeks.
For orders. Item number 4.
And please, your lords, my lord, in this case, my lord, I am asking for the opposite party workman, my lord. My lord, the workman, my lord, after this honorable court, earlier before this honorable court.
1 minute, who is for the petitioner?
May I please, your lordship? This matter was supposed to be conducted by my learned senior Mr. S.P. Mishra, sir. But due to COVID, he has been hospitalized, my lord. So I pray.
All right.
My lord, this is a IM, my lord, filed by the workman, my lord, pursuant to direction of the honorable Supreme Court, my lord. So that is
You heard a submission.
Back, pardon?
Did you hear the submission of the other side?
Yes, my lord.
What do you have to say to that?
Ill, my lord, he admitted in the hospital, but your lordship fix a date, my lord.
All right. Counsel for the court is informed. The senior counsel appearing for the petitioner is unwell. List on 9th November.
Oblige, your lordship.
Item number 5.
Please, your lordship. My lords, here your lordship granted interim bail to the appellant number 1 on 13/7/2021, my lords.
Yes.
And I was directed to file surrender certificate, my lords.
Yes.
I have surrendered on the 13th, my lords.
Yes.
But instead of giving me a free copy, my lords, I was told to apply for a certified copy. I got the copy only on the 19th, so I could not file that surrender certificate. But if your lordship desires, I can screen share with your lordship a copy of that order. Would your lordship like to see the screen share?
No, it's the other side. Ms. Patnaik, are you disputing that he has surrendered?
Oh, Lord, I have my instruction, my lord.
All right. You proceed. What is the matter for today?
My lords, it was fixed for this filing of surrender certificate
All right.
and for bail of the appellants 4 and 5.
So you want to argue 4 and 5?
Yes, my lords. 4 and 5, my lords. The appellants 4 and 5 before your lordships. They are Adi alias Adikondo Sahu and Jubaraj Bhoi, my lords. Both of them are in custody since 21/1/2013, my lords. And this case is based on circumstantial evidence, my lords. None of the circumstances are appear against these two appellants, my lords, and they have been convicted without any iota of materials against them, my lords.
What is the role attributed to them?
Lords, no role at all. It is only the confessional statement of the co-accused, Upin alias Upendra Naik, who has implicated these two persons in a Section 27 statement that inadmissible part has been taken note of to show that these two petitioners were co-conspirators with the other appellants.
So we're talking of Adi and Jubaraj.
Yes, my lords.
They have been convicted with 120B.
They have been convicted, my lords, by the learned trial court, along with all the appellants under Section 120-302 read with 120B and under sections. Yes, only Section 302 read with 34I. I am sorry, my lords.
So there are two deceased here.
Yes, my lords. There are two deceased, and charge was framed against the appellants under Section 302, 120B read with 34 IPC, my lords. If your lordship will look at page 20.
Both the deceased were called to a feast.
They were called to a feast allegedly by a person who was not examined, my lords. One Lambodara Patel, he called them for a feast, my lords.
And what were these two doing there? 4 and 5.
My lords, their presence is not spoken of by anybody except the co-appellant Upin alias Upendra Naik. Your lordship may look at page 26 of the judgment.
So death was homicidal.
Death was homicidal. Two persons were found lying dead near a bridge, my lords, near a culvert.
No, with strangulation or what?
No, my lords, injuries. Homicidal injuries were there. My lords may see page 26 of the judgment.
May I make a submission, my lords? This Patnaik has got disconnected. So kindly pass over. I request my lords.
Oh, I see. All right. Mr. Panda will just pass it over.
My lords.
All right. All right.
Then can it be taken up at 2 o'clock?
All right, 2 o'clock.
Obliged.
Item number 6.
Lordship, my lord. In this case, the appellant convicted 302-201 and 5005 lordships. Here, my lord, that the allegation is lordship that the present input persons along with the child witness PW7 and the deceased had gone to see the Pala, and on the way.
You have to speak louder and into the mic, please.
My lord, in this case, judgment para 7 lordship, that entire prosecution depends on the only evidence of the child witness PW7 lordships. Lordship, kindly see the cross-examination of PW7, my lord, child witness lordship. It is not believable, my lord. Lordship, kindly see the cross-examination by defense lordships.
1 minute, please.
Yes. PW7 lordship.
Just come to para 2 of the judgment. That will give us an idea.
Yes, lordship.
It's a mess, no? The paper book. It's not clear at all. Where is the judgment? Very badly bookmarked. Just read para 2 of the judgment.
Yes, my lord. The prefect of the prosecution case that on 17th September 2014 at about 5 p.m., my lord, the granddaughter of the informant, namely Surya Munda, had been to the house of Dulai Munda to witness Pala. But on 18th September 2014 morning, when Surya Munda did not return to her house, the informant had been to the house of Dulai Munda, and on being asked, she disclosed that they had been to witness Pala, and they were sleeping together and thereafter returned. The informant, along with his wife, family members, searched for the victim. Subsequently, he could notice the bloodstained bedsheet of the victim near the culvert of Devasal Chaka of village Jaladi Canal, and thereafter he also found the dead body of his granddaughter was laying at a little distance from the culvert. My lord. The informant suspected that some culprits had committed the murder of his granddaughter, and thereafter the informant to set the law into motion, presented a written report before the IAC. In this case, lordship, the informant has already expired, lordship. So, in the para 7, my lord, category stated, lordship, that in this case, the entire prosecution depend on the only evidence of the child witness PW7, lordship.
1 minute, 1 minute.
Yes.
No. What's the granddaughter? What's the age of the granddaughter?
Age of the my lord, it was 11 years, my lord.
Sorry?
11 years, lordship.
11 years.
Yes.
So there are also seizures, blood sample clippings, wearing apparel.
It's 16.
So PW7.
Yes, my lord.
Yes, read PW7.
Yes, in cross-examination, my lord, he usually, I do not know the dates. I do not know there are how many days in which I have been going to school for last 5 years. I have come to court today with my mother. The alleged incident took place about 2 years back. I cannot say the day and date as per English calendar of the occurrence. My school is a residential school, my lord. I used to stay in a school hostel, my lord. During the period of occurrence, I was in my home. I only stay in my home on holidays. And on other days, I stay in my hostel. It is a fact that on the day of occurrence, I was in my school, my lord. But usually, he is staying at hostel lordships. Occurrence took place at 5 p.m. lordships. And
1 minute.
yes,
This boy is aged 10 years old,
yes, lordships.
and he says the accused is the son of my elder brother.
Not elder brother, lordships.
Huh? Just see the examination chief.
No, it was the colleagues, lordships. Not elder brother, lordships.
Kindly read the examination chief.
Yes.
What has happened?
That is, this is the granddaughter of the informant, lordships.
Sir, please read. You have PW7 with you?
Yes,
Huh?
my lord.
First paragraph, that examination chief, please
Yes,
read that.
yes. I know the informant Jivan Munda. I know the accused. Standing in the dock, his son of my elder brother.
Is that correct?
Related, my lord. Not
Sorry?
related brothers. Related, not own brothers, lordship. Not own brothers, my lord.
No. So what is, this boy is 10 years old,
Yes.
and the accused is the son of his elder brother.
No, accused not son of my brother, my lord.
The name of the deceased is Surya Munda.
This is Surya Munda, yes.
No. Surya is the name of a girl.
Yes.
I see. What is the motive for this accused stabbing her in the back?
My lord, the cause of death is not known, my lord. Why it's when it consideration, the cause of death is not known. Not known by stated lordships.
What are you saying? Cause of action? Is that how you argue a criminal case? We talk of motive, right? It's not cause of action. What is the motive for the crime?
Lordships. No other stated in judgment also, in the discussion also. Yes, my lord.
Who should it suddenly? Mother of this boy been examined?
Yes, my lord. The mother of the PW7, my lord. PW8.
PW8.
Yes.
The mother herself.
Mother of the PW7 lordships. Lord, the prosecutor has lordship, my lord. Poor lordship, my son disclosed about the incident on the following morning of the occurrence date. By that time, except me, no other person was present. I have not disclosed about the incident to any other person after hearing it from my son. I did not disclose because of fear that my son was witness the occurrence. My son is now 9 years old. I cannot say the date is for English calendar, hence I cannot say date of birth of my son is English calendar. I was present near my son.
See, what is the need for this young boy to falsely accuse you? What is the need for this young boy to falsely accuse you? Or even the mother. See, both of them only know you. You are a co-villager. There is no need for a young boy and his mother to falsely accuse you. Correct?
Nothing is stated lordship in the cross-examination of the judgment also.
No, how do you demolish the evidence of PW7?
Yes. Is it total lordships, but not a believable lordships? Is it not a believable, my lord?
No, why not? You will have to argue why it's not believable.
Because lordships is stated that on the day of occurrence, he was in his school, my lord.
So
and
what?
Usually on the day to use the hostel lordships.
In the evening.
Occurrence took place at 5 p.m. lordships.
5 p.m. not going to school at 5 p.m. Nobody goes to school at 5 p.m. They're proceeding to watch Pala. Pala is the festival.
Yes.
Pala is small.
Pala to see what my lord.
Singing festival. So that they were going in the evening to watch that festival.
Small.
Where is the medical evidence?
Yes, medical notes, my lord, PW 12 notes. So it's
PW 12.
13, my lord, 13.
Does that corroborate the child's version?
The cause of death was due to massive extended hemorrhage leading to shock losses.
No, PW 12 is IU, it.
PW 13, doctor.
PW 1, is it?
13.
13.
Gross examination, lordship, that I have not mentioned in my report whether the X produced before me was stained with blood or not, my lord. The vital question, lordship.
So the medical evidence corroborates the child's evidence.
3 injuries, that's lordship.
Also the scientific evidence.
That bloodstained cloth which was seized, what happened to that? The bed sheet which was seized.
Only
That is leading to discovery 1.
Human blood, is it?
Only human blood, but no conclusive.
All right.
You'll also get from exhibit 9, page 13. The accused has led the team to discover the weapon of offense.
Who is the evidence? Who is the witness to section 27 evidence?
Plus PW 14.
PW 14.
Yes.
There is no PW.
Yeah, there is. Bali Mantri.
Yes.
Yes, Bali Mantri.
Oh, you got the axe recovered.
Yes.
Yes, gross
So
examination.
he has
lordship,
stood firm. You have not been able to break even this PW 14.
Not
It's
supported.
an important witness.
Cross examination, lordship, kindly see the PW 14, my lord. I cannot see the date, month, or year of the cockroach. I was not examined by the police, my lord. I had not seen when the accused had taken Surjamunda with him. I do not remember who informed me that accused had committed the murder of Surjamunda. I had not gone to PS, my lord. I had not seen when police arrested and taken to accused to PS, my lord. It is not a fact the accused had never confessed before me that he had committed the Surjamunda with an accident and conceived the same. I cannot say about the cause of death of Munda. The spot of death was half kilometers of my house. When I had been to spot, no one is present. I have not gone to PS or other spot for concealment of X, my lord.
No.
Not supported, lordships.
That has to read along with paragraph 1, the chief. So that
Para 4. Actually, I have not gone to PS or
Yes.
spot of concealment. But then he says, it's not a fact at the time of seizure, I was
Yes.
not present.
that's what-
What does that mean?
He is the only
he
witness.
has not gone to the spot, but the accused himself has gone to the spot and brought out that axe. That is the reason why he has said that I have not gone to the spot of concealment of axe. That is the reason why I humbly pray your lordship to read paragraph 4 along with the paragraph 1, the examination in chief. The last 4-5 lines you will also find that on Saturday, on being asked, the accused confessed before the police and myself and others that he murdered Suryamunda by means of an axe and concealed the same in a cultivated land, and he would show the same and agreed to give the same. The accused led the police and others to the place of concealment and brought out the bloodstained axe Udia from the cultivated land and gave it to the police in my presence. And police seized the same and prepared seizure list at the spot.
He did not do
I was not specifically, my lord.
That's a
Cross-examination, I was not examined by the police, my lord.
And you also will get it from page 16. that the scientific evidence,
Yes.
it also revealed, it is paragraph 19, last
Yes.
part I am reading, just above paragraph 20. It also revealed that the wearing apparel of the deceased sky color, school shirt stained with O group blood. It further reveals from SFSL report that the wearing apparel of the deceased accused and open offense contain blood group of O group.
And the disease was O group, is it?
O group.
Oh.
But serological report does not show.
Because I don't have that report. Kindly see exhibit
15.
Oh, yes.
Yes.
Oh, I saw it.
O group, correct.
Oh, yes.
And O group is the disease.
No, I just.
Right.
Report.
Right. Zero.
Nothing.
So that is the disease blood group is O. Oh, I think that's a principle.
The doctor also with the process. I have not mentioned in my report whether the X produced for me was stained with blood or not, my lord. The report is not scheduled or six, my lord.
Right. We'll pass the detailed judgment. Appeal is dismissed.
And the X was also stained with O group. That's right, blood group O.
His own wearing apparel. All right.
Item number 7.
May I please, Your Lordship? Item number 7, Your Lordship, on the last occasion directed to list the matter along with WPC number 14941 of 2016, my lord.
Yes.
My lord, it has not been listed, my lord.
No, 16 or 18?
My lord, 16 it is.
IA number you had given?
My lord? No, IA number that is wrongly probably listed, my lord. It is not, IA was never directed to
What is the
listed.
repetition number?
WPC 14941 of 2016.
That is disposed of.
No, my lord, this is a connected writ petition.
All right.
Matter is
List
pending.
along with writ petition civil 14941 of 2016 after removal of all the defects pointed out.
My lord, before vacation, my lord, I pray.
No,
My lord,
after you
people
remove
are
defects.
suffering, my lord, 40 villages.
So you
my
have to
lord.
then remove defects very quickly, sir. Huh? The more they are suffering, the more quickly you have to remove. All right.
My lord, the thing is that, my lord, they are suffering, my lord, your lordship.
I'm
any
sure
part-
you will understand that and remove the defects very quickly. Yes.
Item number 8.
Yes.
May I please, Your Lordships?
Yes.
In this case, my lord, Your Lordship may have a glance upon, my lord, paragraph 3, my lord, of the writ appeal. That it is humbly submitted that for the purpose of auction of the Panchayat Market Complex on the
You did not file. Who is appearing for R13, Sarpanch, Kutura?
I am appearing on behalf
Yes.
30.
All right.
Aklaknama I have given, but already filed, but it
Not
in the list it is.
All right. Yes, please.
my lord, in
Your
paragraph 3,
Lordship directed, my lord, to file a paper book. Paper book, my lord.
Whom are you for, sir?
My lord, I am for the private opposite parties who are allotted in the shop room on in the basis of the rehabilitation scheme.
So private opposite parties are 2 to 11.
Annexures, my lord, written in
2 to 11.
vernacular.
2 to 11.
2 to 11, my lord.
So you don't have paper book.
My lord, paper book, my lord, means, my lord, they have, my lord, along with writ appeal and the judgment of the honorable single judge and along with annexures with vernacular. Unless and until it has been filed, my lord, it's a very difficult and PESA Act is, my lord, involved in this case. And the private opposite party allotted the shop room on the basis of the rehabilitation scheme in the year of 2015. And they have not challenged, my lord, my allotment in the year of 2015. And they came to the picture, my lord, in the subsequent, my lord, decision of the Grama Sabha. They kept in advance in the 2015 decisions and allot the.
No. Are you ready with the arguments or you want time?
My lord, may I pray, my lord, your lordship fix a date for hearing, my lord, and my lord prepare a paperwork. Thereafter, your lordship had and the proper adjudications of the both the parties, my lord.
my lord, they are knowingly lingering the case.
My lord, your lordship fix any date, my lord, for hearing.
To harass the innocent tribal persons, my lord. They are knowingly.
My lord,
doing it.
one person they have
They
challenged
demanded,
the
my
appeal,
lord,
my
the
lord.
copy. I will
11
furnish the
persons-
copy. And again, also when the last occasion your loss is directed on the basis of their request, my lord, I have sent them. So everything is okay. And they are the petitioner in that case. So the judgment is supposed to be with them.
Correct.
And they are now demanding I am the opposite party in that case. And now they are demanding that I will furnish them the judgment copy. I cannot understand, my lord, whatever they are doing, my lord, only, my lord, they have pursued the case, approached this case, my lord, suppressing the facts. If they will, your lordship will permit me, my lord, I will open all the chapters, what they have did.
Yes, proceed.
My lord, your lordship may have a glance, my lord. Whatever, my lord, he is submitting. So let me clarify his view, my lord. He has told that on the basis of, your lordship may have a glance upon, my lord, they are petitioner. Let me disclose the facts. My lord, they are telling on the basis of their annexure number 1, my lord, 17th of January 2015 resolution, they are getting that market complex. My lord, they have said when the Gram Panchayat has decided, they told. But whenever the Gram Panchayat has dismissed and cancelled the proposal, they have not approached, they have not mentioned it before this honorable court. So that, my lord, I have annexed, my lord. Your lordship may have a glance, my lord, page number 46 of the writ appeal. My lord, that is in regional language written, my lord. 17th of 2015 means 17th of January 2015 that resolution is cancelled. Right? Resolution dated 2nd of October 2017. But they have not annexed this document and they have not disclosed this fact that their resolution is already been cancelled against them. Only whenever there was another thing, my lord, your lordship may have a glance, my lord, to my read in the read, my lord, the counter, paragraph 7. They given the false statement, my lord, that in reply to, my lord, read, that is in the read, my lord, counter affidavit, para 7.
Yes.
That in reply to para 3 of the read petition. In para 3, my lord, they have stated that para 3, my lord, they have stated that the facts of the case leading to filing of the present writ application are that the petitioners were originally roadside vendors in and around Kutra bus stand of Sundargarh district, and in the year 2015 there was a proposal for expansion of this state highway number 10 from Sundargarh to Sambalpur. As because the petitioners had been doing their business since last decade, the sudden expansion of on the highways forced the petitioners to evict their piece of land. Evict their piece of land. It is false. It is the market complex of the Panchayat which was demolished. But they are telling that they will be rehabilitated. Here they stated that their piece of land for public cause, and petitioners were also assured by the district administration that their concern will be aptly addressed and alternative sites will be provided to them. So that is not their market.
So what was, how are you involved? Whom are you representing? What is your position here?
My lord?
In the writ petition, you were opposite party number?
The writ petition, my lord, I appeared for all the opposite parties.
4 to?
All, my lord.
4 to 16?
Yes.
What was the allegation against you?
My lord?
What was the allegation against you?
My lord, I am the...
In the writ petition, what was the allegation against you?
Against me, my lord, in the auction sale notice, that is in annexure number 9, my lord.
No.
49, page number of the writ petition. The first allotment was in our favor. There was a lottery, my lord.
And you got allotted?
Yes, my lord. I was appearing for all the opposite parties, and all the opposite parties.
One person's, my lord, filed appeal, and they have not implemented other
opposite parties.
Not necessary. Similar interest, my lord. My lord, your lordship may have, my lord, in page number 54 and 55 of their writ petition. The opposite parties were allotted the shop rooms under fresh auction made by the Gram Sabha under the recommendation made by the Gram Panchayat on the recommendation of the Gram Sabha. My lord, this is the Pesa area, my lord. Your lordship may have, my lord, glance to 59 section. Section 59 of the Gram Panchayat Act. Section 59, my lord. To which, my lord, single just told that it is not applicable. How it is not applicable? It is the civil area, and civil area law is not applicable to civil area. So it is turning, my lord. I may place, my lord, the section.
Yes.
My lord, section 59. No person shall open a new market, private market after the commencement of this act, or continue to keep open a private market unless he obtains from the Gram Panchayat a license to do so for a period not exceeding 1 year in the prescribed manner, and such license may be renewed every year. And this provision is applicable to civil area, my lord, provided that in the civil areas, the Gram Panchayat, subject to the control and supervision of the Gram Sasana, shall have power to manage village market by whatsoever name called. So whatever decision, my lord, taken in that writ petition, my lord, that is annexed number.
So this is a civil area.
My lord?
Your area is a civil area.
Civil area. So Sundargarh is a civil area, complete civil area.
Schedule area. Schedule area.
Yes, ma'am.
Yes.
My lord, in annexed number 9 of their writ petition, my lord, your lordship may have a glance, my lord, which was quashed by the Honorable Single Judge, my lord.
So this is a basic error that the learned single judge has said this provision has no application.
No application.
Whereas the proviso squarely applies.
Proviso applies. And also that is once, my lord, that is also Pesa area, my lord. So Pesa Act, my lord, your lordship may.
Extension of schedule areas.
Yes, Panchayat extension of schedule areas. My lord, section 4M. Section 4M, my lord, it clearly states.
So right now, who is in possession?
They are, my lord. They are not living, my lord. That is they are also, my lord, non-civil. They are the migrant people. They are non-civil. That market complex is constructed from the Integrated Tribal Development Fund. So the tribals will be the beneficiary. They are the non-tribals, my lord. Possibly another thing, my lord.
All your clients are tribals.
My lord?
No. Your clients are all tribals.
Yes, my lord. All are tribals.
So what about his plea? He says only one of you has filed this appeal. What about the rest?
Exactly.
In the writ petition, there were about 14 of you or 13 of you, right?
Yes, my lord.
What happened to the remaining? Only one has come in appeal here.
My lord, they could not come at that time, my lord, because there was the cyclone, my lord, and they are. That's why only one, my lord, similar interest, my lord. All they are similar interest, so they could not come, my lord.
No, but the cost title has to reflect all of them, no?
My lord.
My lord, may I submit one thing to your lordship?
The cost title. File a writ appeal against the writ petition.
Treated as pro forma
Yes. You are Miss Panda.
Yes, ma'am, Mrs. Panda.
Mrs. Panda. So whenever you are filing a writ appeal, you have to make all the parties present before the writ petition, in the writ petition, as parties in the appeal also.
Perhaps that was the last order. Your lordship may kindly see the order sheet. Perhaps that was the direction in the last order. To include all the parties. But one thing may I be permitted to submit, my lord?
Yes.
Your Lordship may kindly see, the order was passed against 14 private individuals. 13 are not in appeal. They have accepted the order. Only one is the.
That's the point he's making, but
And
she
he-
says she's representing all of the others.
No, that is not the case. That is not the cause title never discloses that he is the appellant is the representative of other opposite parties who have not preferred appeal before
If
this.
your lordship will permit me, then I will amend and they will come.
Because why I am saying this, in the impugned order, your
They have
lordship will
not
see,
accepted, my lord.
your lordship will see, the opposite party's interest was protected. Their 10 shops were, still 7 shops are there, and the learned single judge has said that auction will be held. She is only one. There are 7 shops again available for auction. She can participate in that.
Law, my lord, does not say so. That is, that market complex was constructed out of the integrated tribal development fund. So the
Or your lordship can,
my lord, again, my lord, most respectfully,
without
submit before
recording my
lordship,
concession,
my
if
lord,
your lordship will
those who
allow
are
her to take.
possessing, please, those who are possessing the market complex, my lord, they are having their own house, the own market also, they have given them on rent. They are monetarily, they are affluent, my lord. Their names, my lord, your lordship may say they are not the tribals, my lord. They are, my lord, they are exploiting these innocent tribals. They have the right, but they are forcibly taking away their rights. Since long, my lord, they are operating those shops and also submitting that they are coming here on the.
What is the Gram Panchayat? You are the Sarpanch. What is your stand?
The fact is like this. This earlier, those 10 persons, they were having the shop rooms that was demolished, but admittedly that is the property of the Panchayat. But later on, after coming into force of this development for tribals and all, those some of they were not aware about their rights. They made an application to the governor, honorable governor, my lord. Then thereafter, under the instruction that now the collector DPO passed the order that actually this for the benefit of the tribal people, this is to be done. Then the Sarpanch, at the instruction of the DPO and collector, they hold the resolution they have passed that, my lord, DPO's letter, my lord, has been filed that 75% of the shops will be allotted to the tribal people and 25 to the general people. And accordingly, the earlier resolution that was rejected, cancelled, and thereafter another resolution has been passed. And actually these people, this now present private opposite parties, keys were also handed over to them after construction of the new rooms. Then order was passed that please give back these keys of the sub rooms and all, because as your lordships also knows that tribal areas, why that is not being developed because of the lack of awareness. Then thereafter some people they are educated.
No. So the only point is this: among the people who were opposite parties in the writ petition, only one of them has filed the appeal.
Yes, your lordship is absolutely correct. They should be made parties in the writ appeal also. By mistake, most probably Mrs. Ponda has not been made. That maybe that correct. And another thing that
No,
was not
they all,
restrict-
Mr. Mohanty says they are not aggrieved by the order of the single judge. Is that correct?
No. One thing, my lord, they may remain silent.
That is supposed to be.
The right of the present appellant, one of the person agreed, always he can come to the court. That
No issue. One of the person
Others
can
are also, my lord, agreed, my lord. If your lordship permit me, my lord, they will come. At that time, my lord, that was the cyclone area, cyclone time, my lord. When
No, but whatever, you still had to make them
That is
party.
technically-
You can't just drop parties who are parties to the
yes,
writ petition.
Your lordship may fix that, my lord, all the parties will come before your lordships.
All right, it is seen that in writ petition civil 16629 of 2018, out of which the present appeal arises, there were 8 opposite parties. That is opposite parties 3 to 10. Sorry, they were 4 to 16, 13 opposite parties. That is opposite parties 4 to 16. Of these, only one of them has filed the present appeal. One of them, Budaram Lakra,
OP number 8 perhaps.
opposite party number 8,
And OP3 also appeared.
No, 3 is not a private respondent.
has filed the present appeal. Paragraph. Counsel for the opposite parties 2 to 11, who succeeded before the learned single judge, points out that the cause title in the present appeal could not have been drawn up by dropping the other contesting respondents in the writ petition. Paragraph. Mrs. Pandal and counsel the appellant then makes an oral prayer that the other contesting respondents, that is, opposite parties, (3 to 7) and 9 to 16 in the writ petition be implemented as pro forma respondents. (14) onwards in the present writ appeal. The prayer is accepted. The consolidated cause title of the writ appeal will now be filed within 1 week with the requisites for service of notice in the writ appeal on the added pro forma respondents. Returnable on the next date, 7th December. All right.
Item number 9.
In this case,
The affidavit comes.
yes, I was supposed to file an affidavit on behalf of the state. With the Lord's permission, I am filing it in court.
Lords, may I submit? Your Lordship may look at order dated 24th of August 2021. There was a specific direction that Mr. Katkia should file his affidavit within a specific time.
After getting all the documents, I prepared the affidavit and.
Lords, what documents? There are 4 FIRs. They were all there with him, my lords. If the scales of justice are even, my lords.
What is the date of the order you said, Mr. Panda?
24th of August.
It's number 13, digital.
So 23rd August. 23rd August. Yes.
I'm sorry, it's 23rd.
No, 24th only.
24th.
Mr. Katkia opposes the application, stands on a different footing. He states he wants to bring on record the criminal antecedents and subsequent conduct of the present appellant. An affidavit be filed. What happened?
Yes, I have filed the affidavit today in the court with the Lord's permission. I am filing it. I prepared it yesterday because I have got the documents from the.
I had made a mention in the morning, my lords, to the effect that I have filed an affidavit. I have served copy on the state.
That affidavit is also come on record. Now he has filed an affidavit. You have to have a copy of that.
I have served a copy on the state.
No. Mr. Katkia has today filed
I
an
have served a copy, my lords. Electronically, yesterday evening I was served with a copy.
All right.
I have served a copy yesterday, but the affidavit filed by Madam Senior, today I have got it in the morning, of course, from the office.
Now here is the prayer for bail of which appellant?
Sole appellant in criminal appeal 503.
He is Shamsundar Prusti, the principal accused.
Shamsundar Prusti.
I am not the principal accused. I have not been charged under 302 simpliciter or 302 read with 34 simpliciter also. The 2 persons who are charged of having committed murder, they are not before you today.
I pray for a short adjournment. I will go to the affidavit filed by Madam Senior.
All right.
Tomorrow?
No.
All right. Well, the state has filed an affidavit pursuant to the order dated 24th August 2021. Mr. Panda, learned senior counsel for the appellant, has also filed an affidavit enclosing certain documents, a copy of which has been served on Mr. Katkia, the learned AGA. Paragraph: Mr. Katkia seeks some time to examine the affidavit filed by Mr. Panda and make submissions. At his request, list on twenty-eighth September.
Lords, may I make a small submission?
Yes, Mr. Panda.
Lords, the order sheets of your lordships, my lords, which were being uploaded, and they continue to be uploaded, because I was checking, those orders are not being uploaded now.
No, those all the orders are being uploaded, Mr. Panda.
No, my lords,
The orders are being uploaded.
I was checking this appeal, that order sheet dated 24th August.
There may be some single or two cases. There may be some difference.
That's why.
Orders are.
Anyway, we'll double check it. We'll make sure of that audit.
Item number 10.
Please, my lords, the petitioner state has challenged the orders passed by the Honorable Civil Judge. Let's kindly find the order at page 124.
No, first of all, there's an IA for appropriate orders with regard to correction of the description of the respondents. That's all over.
No, my lords can see the order dated 5/4/2021 in IA number 686 of 2021. Your lordship have directed the state to correct the cause title by giving the proper description of the opposite parties who were the petitioner in the writ petition, my lord. Thereafter, my lord may have a look to order dated 21/6 to 2021. 21st June 2021. There, my lords have directed that we filed an IA, that is 1175 of 2021, wherein we have described the correct description of the petitioner, who are the petitioners, now they are the respondents. Your lordship will get that at paragraph 7 of that IA 1175 of 2021. I have described that they are the petitioners before this honorable court in the writ petition, and the certified copy obtained by the state would also reflect that their names have been described in that manner. And accordingly, my lord, the opposite parties have entered appearance through Bhakratrama. But since a wrong description of the name has been there in the writ appeal, that is why the stamp reporter has objected their appearance. I have described it paragraph. I have described it.
Since they have already appeared and have taken notice to all of them, I'll do the needful. I'll file a corrected cost.
All right, 117.
That should be done.
The prayer in the present application is for a direction to the state appellant to file a consolidated correct copy of the cost title.
Yes,
as per the descriptions of the respondents given in the writ petition filed. The application is allowed. A direction is issued to the appellant to file the correct consolidated cost title of the appeal corresponding to the cost title of the writ petition within 1 week. You see, Mr. has entered appearance on behalf of on the behalf of the contesting respondents of the present appeal.
Copy may also be served to the advocate for the opposite party 25 and 26.
Everybody will get copies.
Mr. Purohit, I'm sorry.
Mr. Jayant Kumar has already entered appearance. Now there is a noting, Mr. Sahu, that some respondent 4 does not, there's no such addressee or something.
I'll take fresh steps. Also R2, Lordship.
The office report is that R4, the notice to R4 has been returned with the remarks single quotes addressee absent. Also, neither AD nor the undelivered notice has been received from R2. fresh steps be taken for service of notice on R4. List after 12 weeks.
Item number 11.
May I please, Your Lordship? Your Lordship, right, order dated 23/6/2021, Your Lordship has issued notice on the question of limitation by 89 days delay. That, Your Lordship, on page 76, the order that the related allowed Mr. case, now single have disposed of the matter, page 76.
What has happened to that SLP is still pending?
Yes, ma'am, that SLP is pending.
All right. It is stated that the specially petition is still pending in the Supreme Court. List after 12 weeks.
Item number 12.
Interim order to continue, ma'am.
Interim order to continue.
Item 12.
Sarpanch of the Gram Panchayat, Annexure 1, page 11, requested.
So you have to remove the defects. List after removal of defects.
Item number 14.
Sub-item, because the STREB 25 of 2010 and the other connected STREB 26 of 2010, the Honorable Tribunal says that the outcome of this matter will depend upon the outcome of this Millards Jaipur Sugar Limited. So, Your Lordship may kindly take up STREB number 6 of 2005.
All right.
That's now, plus I will pay your Lordship to kindly turn to page 124, in which the question of law is framed by your Lordship.
What's the order date?
That's order Millards. 16/7/2009 minus. Page 124 minus. Annexure 16 minus.
Correct.
Minus.
Furnace permanently embedded to the earth, being immovable property, can still be liable to sales tax,
Exactly.
sale of machinery. Furnace
Second
is covered under machinery. All right.
Second question may be kept in abeyance because the first question is dominant question. Millards.
Yes.
That's now, Millards, the Lordship may kindly turn to the findings of the tribunal, Millards, at page 72.
Yes.
It is next contended by Mr. Raman, though not stated in the grounds of appeal, but that furnace being an immovable property, taxing the same doesn't come within the domain of OST Act. It is strenuously urged by Mr. Raman that Section 221 of the Orissa General Classes Act, which is perimetria with Section 325 of General Classes Act 1897, immovable property means and includes land and things attached to earth are permanently fastened to handling attached to earth. It is further added that since furnace has been permanently embedded in the earth within the premises of the dealer appellant, the same can safely be said to be immovable property. To convince us, the appellant has also filed a photograph of the furnace showing its construction inside factory premises of the appellant. But simply because the furnace has been permanently embedded to the earth, that itself is not sufficient to hold that it is not machinery in view of guidelines 1 and 2 laid down by the Honorable Apex Court, reported in 44 STC at page 276 Supra, wherein it has been clearly observed that machinery must mean something more than a collection of ordinary tools, and it must mean something more than a solid structure built upon the ground, whose parts either do not move at all, or if they do move, do not move the one with or upon the other in interdependent action. Therefore, even if the furnace has been fixed to the ground, that itself is not sufficient to hold that it's an immovable property and not machinery liable to tax. If the furnace is an immovable property as claimed by the dealer, then the parties at the time of sale could have executed registered sale deed as per Section 54 of the Transfer of Property Act on appropriate stamp paper, paying necessary registration charges. But they have not done that. And treating the furnace as goods affected the transaction of sale against declaration in Form 34. When the learned STO observed that machinery is liable to tax at the first point of sale, and the appellant is liable to pay tax on sale thereof, the letter now comes forward that it's an immovable property, sale of which does not come within the domain of OST Act. This shows that the appellant takes different stands at different times to suit the purpose for which you are not prepared to accept. Moreover,
from the discussion above, we have already come to the conclusion that though the furnace is embedded to the earth, that does not lose its character as machinery, and such a stand has not been taken in the grounds of it. We are therefore the view that both the fora below have very rightly levied tax on self transaction of such furnace at the appropriate point with which you do not like to interfere. My lords, this is a case where learned tribunal relied upon one judgment of the Honorable Apex Court, that is 44 STC at page 276. That judgment that refers to trailer, tractor trailer. That has nothing to do with the present case. And before your lordship, we must know, what is the furnace is. That is very important to know. Because for that, I will take your lordship's attention.
Let us look at some examples, Mr. Sahu.
My lords.
There are so many pipeline projects, right?
Exactly.
Where pipelines are laid across the earth, maybe even between two cities.
My lords. There are some judgments.
There are huge, there are huge pipes.
Exactly.
Then you construct concrete, whatever, columns.
My lords.
You lay the pipes over those columns.
Absolutely.
So one is that till such time they are embedded, the way you are suggesting, and those pipes for all purposes are thereafter removable, correct?
Right.
But you can remove those pipes, and till they're fixed onto that concrete pillar, they are movable. You purchase them as movable pipes.
Right.
What you do with the pipes later to make it immovable is up to you.
Right.
Tomorrow you want to replace this pipe, you will again purchase a pipe, remove this pipe and fit it.
Correct. Yes.
While it is in operation, it may be immobile, it may be immovable.
Right.
But as a pipe, it is still purchased. At the time of purchase, it is still a commodity that can be lifted, moved, and brought to the site to be embedded.
Right. Yes.
Likewise, a furnace. Tomorrow you want to replace this furnace with another furnace.
Correct.
You dismantle this furnace, bring in that new furnace and fix it.
That is the question, Milords. Rightly, your lordship have put this. Because as per the, I will submit the chartered metallurgical engineers technical report and also some judgments on the issue. And the principle is, Milords, it is the magnitude of embedment that matters. If, Milords, for removing the structure, Milords, it will end in scraps. It cannot be removed. Then it will be called to be immovable.
No. Let me give you another example.
Minus.
Today you go to buy a factory.
Absolutely.
The factory is sold as is various bases.
Minus.
Inside the factory, there are several plant and machineries already embedded.
Right.
You purchase the whole factory.
Correct.
As a lump sum.
Correct.
Nobody is going to charge sales tax at that point.
Minus.
They are not going to say that you purchased this pipe alone or this furnace alone.
Minus.
But if all that was dismantled and kept aside, and you are purchasing only that, maybe it will attract sales tax at that stage. We don't know. I'm just saying it can be second point of sale, third point of sale, whatever.
Minus.
But buying it in a manner in which it is embedded is one thing. Buying it when it is still movable is another.
Minus. So, Milords, let us know first, Milords, my humble submission would be, what is the furnace in this case? What is that, Milords? Your Lordship will find out from page 76. What is the furnace, Milords? Page 76, Milords.
Yes.
This has also been discussed. It is established practice that ferroalloy furnace are built in situ from the ground and top to 30 meters above height. The furnace is similar to blast furnace used in steel plants, being called low shaft furnace, and instead of gas, electrical energy is used for smelting operation. The ferroalloy furnace having 7.5 MVA capacity, which installed and commissioned in the year 1957, and it's operational since then, till date, in the premises of Jaipur Sugar Company Limited, Raigada, along with accessories and accompaniments, and is firmly based on concrete foundations, and accessories that too are fitted in such a manner that they are not moved at any time. Hence, the plant is immovable. The furnace with its internal brick lining will weigh about 600 tons. It is fastened to RCC foundation having load-bearing capacity of 85 tons per square meter. The entire structure is 3-storied, top height at 30 meters. The furnace is circular shape, rigid cell which has bottom dia of 6,050 mm and top dia 6,785 mm and depth of furnace is 1,700 mm. Inside lined with refractory bricks to withstand high temperature introduced to huge electrodes. The heat ranges from 1,300 degree to 1,800 degree Celsius to melt ores into the furnace. In this case, it is required to remove from its base foundation of which is made on earth will result in scrap, and that cannot be utilized for the purpose of manufacture, or it cannot be utilized for the purpose for which furnace is required to be used. The entire plant, structure of the plant, layout possesses immovable character. The cost of the now he has given the split up. The cost of the entire plant.
You're asked to pay sales tax on what? Which of this?
Exactly. But what has happened? In fact, initially some mistake was committed by this petitioner, giving rise to all these problems. The mistake is, your lordship knows, in this commercial world now, there has been a new concept of this lease come buyback policy. Because this appellant is suffering from financial problem. So to get rid of financial problem, what it did, it made some arrangement, some methodology that is adapted with the other petitioner, your lordship, which skipped over for the time being now, the CFL Capital. CFL Capital, I was in need of money. They financed. For that, we made some intra-arrangement. That is, I sold the entire machineries, everything in as is varies, wherever it is, by raising an invoice on CFL. So now CFL became the owner, and that on the very same day, by another agreement, lease agreement, CFL leased out that plant to me on monthly rental. Well, my lords will kindly see the transaction. What I did, these machineries, I sold that as if these are goods. So I said that this is to be used for against Form 34. Form 34 is used when any taxable goods are sold. Realizing the mistake which I have committed, before the forum below, I brought to the notice of their forums, saying that this transaction under Form 34 is a mistake. Your lordship, I have therefore given one judgment today morning to your lordship. Admission cannot be a factor for taxation. This honorable court, relying upon honorable apex court, they said that whether something is liable to tax or not, that can be decided within the four corners of statute. Supposing I have committed some mistake or wrong, that cannot be a basis under the Constitution, entry 54 or 265 to levy tax on that. So therefore, now the best question is whether it is movable or immovable. Now my
One minute. You still not answered my question.
Sorry.
When you sold it to CFL Capital,
right?
You sold the entire civil work structure, main furnace plant, everything, or you are?
What I sold, I have annexed the invoice plus all the whatever equipments, plant and equipment sold. I have not mentioned the land. Because the land.
So there could still be an arguable case, therefore, that even going by the certificate issued by this qualified lead assessor, which you just read, in that entire structure, there could be one component which is still a movable component, correct?
No, my lords. That is the issue, my lords.
The main furnace plant, you see, what happens is, you bring in that furnace, and when you embed it in that concrete structure, then you do the brick lining, then it becomes the actual furnace which you're going to use in your manufacture. But that component, that furnace element which is there, which you're embedding on the ground, that itself is purchased separately.
It's a virtual transaction. I can tell you, your lordship can realize it's a virtual transaction. In this sense, nothing is severed. It is as it is there for money's sake. Because I want money, I don't have money to carry on business. I entered into arrangement with CFL Capital.
No. Are they putting that entire value? You yourself put that entire value as a Form 34 to pay sales tax.
Minors. Entire transaction.
So are you still contending that you don't have to pay sales tax at all on any of it?
Absolutely, Milos, because this is an immovable property. It cannot come within the purview of entry 54, least to 7 schedule, Milos, as my lords knows. And I will take your lordship's attention to various judgments, but the principle is decided, including Privy Council judgment, where Honorable Privy Council said there cannot be any inflexible formula to define machinery. It will all depend upon case-to-case basis. It shall be dealt in. And some principles have been also enunciated by subsequent judgments of Honorable Apex Court. Let us, I am, Your Lordship, permit me, I will take your
What you have
Lordship.
sold is the entire furnace as it is, with all that brick lining, everything.
Absolutely. The reason being, Milords, the equipments which are already embedded on earth, that cannot be severed even if I raise a bill for that equipment. Your Lordship, it's a fictional rather sale. It's a sale only for the purpose of Milords arranging funds. It's in modern concept. This is called a lease come buyback policy, Milords. Because I have my own, my machine doesn't go elsewhere. My plant is there with me. My machinery equipment there with me. But for money, I sell to X, the lender, and he finances and leases back again the same thing which is already in my possession. Possession or machinery status doesn't get disturbed in any manner, Milords. So therefore, Your Lordship have to live well. Because Your Lordship have to live well and understand the transaction. Whatever, essentially, what is this? Whether it can utter the goods. Now, I take Your Lordship's attention, Lords, to Annexure 17, one judgment, Lords, at page 125. That is TTG Industries case, Honorable Supreme Court in 2004, paragraph 27. Only I will be, Lords, take Your Lordship to relevant paragraph. It may not be detain Your Lordship much, Lords. Paragraph 27, Lords. In that case, the question was the installation of hydraulic band guns and tap hole drilling machines. Keeping in view, may I place my notes, page 127, para 27.
Yes.
Keeping in view the principles laid down in the judgments noticed above, and having regard to the facts of the case, we have no doubt in our mind that mud guns and drilling machines erected at site by the appellant on a specially moored concrete platform at a level of 25 feet above on the ground on a base plate secured to the concrete platform brought into existence not excisable goods but immovable property which could not be shifted without first dismantling it and then re-erecting at another site. We have earlier noticed the process involved and the manner in which the equipments are assembled and erected. We have also noticed the volume of the machines concerned and their weight. Taking all these facts into consideration and having regard to the nature of the structure erected for basing these machines, we are satisfied that the judicial member Segat was right in reaching the conclusion that what ultimately emerged as a result of process undertaken and erection done cannot be described as goods within the meaning of the Excise Act and exigible to excise duty. We find considerable similarity of facts in the case of at hand, in the case of methyl engineering and quality steel tubes. And the principle underlying those decisions must apply to the fact of the case in hand. It cannot be disputed that such drilling machines and mud guns are not equipment which are usually shifted from one place to another, nor is it practicable to shift them frequently. Counsel for the appellant submitted for us that once they are erected and assembled, they continue to operate from where they are positioned till such time as they are worn out or discarded. According to him, they really become furnace, they really become component of the plant and machinery because without their aid, a blast furnace cannot operate. It is not necessary for us to express any opinion as to whether the mud guns and drilling machines are really a component of the plant and machinery of the steel plant, but we are satisfied that, having regard to the manner in which these machines are erected and installed upon concrete structures, they do not answer the description of goods within the meaning of the term under the Excise Act.
Right, right.
Now, my lords, the next judgment, I will take your lordship's attention to Duncan Industries case, which has been very often followed in very many judgments, my lords, at page 139, annexure 18, my lords.
Right.
But the question in that case is answered in paragraph 8, my lords. 8 and 9, only two paragraphs will suffice, my lords.
Yes.
As considering the question whether the plant and machinery in the instant case can be construed as immovable property or not, the High Court came to the conclusion that the machinery which formed the fertilizer plant were permanently embedded in the earth with an intention of running the fertilizer factory, and while embedding these machineries, the intention of the party was not to remove the same for the purpose of any sale of the same, either as a part of machinery or scrap or in the very nature of the user of these machineries. It was necessary that these machineries be permanently fixed on the ground. Therefore, it came to the conclusion that these machineries were immovable property which are permanently attached to the land in question. While coming to this conclusion, the learned judge relied upon the observation found in the case of Renault so and so and so and so. We are inclined to agree with the above findings of the High Court that the plant and machinery in the instant case are immovable properties. The question whether a machinery which is embedded in the earth is movable property or an immovable property depends upon the facts and circumstances of each case. Primarily, the court will have to take into consideration the intention of the parties when it decided to embed the machinery, whether such embedment was intended to be temporary or permanent. A careful perusal of the agreement of sale and conveyance deed along with the attendant circumstances and taking into consideration the nature of machineries involved clearly shows that the machineries which have been embedded in the earth to constitute a fertilizer plant in the instant case are definitely embedded permanently with a view to utilize the same as a fertilizer plant. The description of the machineries as seen in the schedule attached to the deed of conveyance also shows that without any doubt that they are set up permanently in the land in question with a view to operate a fertilizer plant, and the same was not embedded to dismantle and remove the same for the purpose of sale as machinery at any point of time. The facts as could be found also show that the purpose for which these machineries were embedded was to use the plant as a factory for the manufacture of fertilizer at various stages of production. Hence, the contention that these machineries should be treated as movables cannot be accepted. Now, nor can it be said that the plant and machinery could have been transferred by delivery of possession on any date prior to the date of conveyance of the title of land. Mr. Verma, in support of contention that machinery question are not immovable property, relied on judgment of this court in Sherpur Paper Limited versus CCE. In the said case, this court, while considering the levying of excise duty on paper making machines, based on the facts of that case, came to the conclusion that the machinery involved in that case did not constitute immovable property. As stated above, whether a machinery embedded in the earth can be treated as immovable or immovable property depends upon the facts and circumstances of each case. The court, considering the said question, will have to take into consideration the intents of the parties which embedded the machinery and also the intent of the parties who intend alienating the machinery in the case cited by Mr. Verma. This court in paragraph the judgment has observed this case.
So I think in para 10,
minus.
What I was mentioning too, that as is, where is basis.
Minus.
That is mentioned, including land, building, plant and machinery, description of which is found in the definition of the term fertilizer business in the agreement itself. So they say if it is like that, you cannot separate out one thing to say that is immovable property and this is movable.
Minus. Paragraph 9 for a moment, then I will use. From the above observation, it is clear that this court has decided the issue in that case based on the facts and circumstances pertaining to that.
Much here. No, so basically in your case, Mr. Sahu,
minus.
So in your case, you are saying you simply sold it as such to the CFL Capital, which then rented it out to you again.
But in my case,
dismantling, you did not do anything.
Minus. I didn't do dismantling, nothing. The dismantling is not there. Only the machinery and equipment.
Let's hear the other side now. Let's hear the other side.
There's some more judgments.
That's okay. It's all the same thing now. You don't have to read so many judgments. Let us see what the department says. Yes.
I will come back with other judgments.
If they cite anything, let us see what they say.
May I please?
Yes, Mr. Badi.
The issue here is whether that furnace, transfer of that furnace is in.
Yes, that furnace which they describe is not just the metal part of a furnace.
Yes, ma'am.
The furnace doesn't move anywhere. It is already there. It's embedded. It's brick lined. It's in a concrete structure, and that entire thing has been sold as such. They've not separated out the component parts.
Yes, ma'am. The first thing is that the furnace per se is movable. But what they contain is that since it is embedded to a concrete structure, it is an immovable.
Correct.
And the judgments which my learned senior read out, that says the intention of the parties is paramount. The erection, the manner of erection. So the intention of the parties is paramount. Now, my lord, if I will take your lordship, what was the intention of the parties at that point of time while erecting this, while selling this? So, my lord, may kindly turn to page 115.
All right.
Registration certificate of the petitioner under the Act, my lord. Page 115, Annexure 11.
Yes.
My lord, if your lordship would find column number 7, left. Sale of the following goods to the dealer will be free of tax for resale in Orissa. This is the pursuant to declaration of the petitioner. This certificate has been granted, and he has declared that he will be dealing with these goods. And I could find flameless furnace is there.
That's right. So that flameless furnace, how is it there? I mean, it is not there as something that you can lift and move.
No, my lord, my whole endeavor is to show that what was the intention of the party. So at the time,
correct.
He has intended it to be a goods. Then, my lord.
No. It's the other way around. The intention is not that it should be sold as goods. See, they have said that the sale of the following goods will be free of tax.
Yes, my lord. So he has declared that he will be dealing with these goods at the time of applying for registration, my lord. One.
All right.
Next, my lord, may I kindly turn to page 80, Annex 6. Page 80.
The invoice.
Yes, my lord. This is the invoice that was raised by the petitioner at the time of sale to the CFL, my lord.
Right.
If your lordship would kindly see, sale of flameless such and such, it's 11,37,051.
11 crores. 11 crores.
And this breakup of this 11 crores is at page, my lord, 97. Individually, the goods have been valued. The market value has been specified of the individual goods of that furnace. Page 97.
But is it sold individually is the question, Mr. Padi.
Yes, my humble submission is that.
No, the intention was not that we'll dismantle it and sell it like this.
But my lord, he has sold it like a goods. He has raised a
All right.
Yes, my lord. Then another thing which also points to his intention is that at the time of this sale, my lord, he has furnished a declaration form 34, my lord. That declaration form is given pursuant to section 5 capital A 2. My lord, may kindly see section 5 capital A 2 of the OST Act. My lord, may kindly see that for a moment.
OST Act.
Section 5 deals with rate of tax. My lord, may come to clause 2. Clause 2, capital A, which says that in this act, the expression taxable turnover. Let us got it.
Yes.
In this act, the expression taxable turnover means that part of the dealer's gross turnover during any period which remains after deducting therefrom A, his turnover during that period on, we are considered clause 2(y), my lord. Sales to a registered dealer of goods specified in the purchasing dealer's certificate of registration for resale by him in Orissa in a manner that such resale shall be subject to levy of tax under this act, and on sales to a registered dealer of containers or other materials for the packing of such goods. Now, a declaration under this section has been given by the petitioner, and that declaration is annexed.
The argument there is he admits he made a mistake. So he is citing decisions to say merely because I made a mistake, I cannot be made to suffer. You have to still go and see what the legal position is.
Yes, madam. But the mistake.
So even the assessee's declaration of what it is not sufficient. If it is otherwise not taxable, there is no estoppel. This is what he's trying to plead.
Yet there is no estoppel against the law. Says that the intention of the parties is to be seen. Now, the intention of the parties is to be gathered from the contemporary documents. Now, all those contemporary documents, the registration certificate, sale invoice, the declaration which says that it has been sold.
The other intention is, see, sometimes you sell a factory in order to dismantle the whole thing, sell away individual components. Here, the intention was not to do that. It was actually for them to continue using the whole thing.
No, my lord.
This was simply an arrangement by which, like nowadays, you have even for elderly citizens. You sell your ultimately you will sell it to the bank, but every month you will get something because this house is already given to the bank.
These are financing arrangements, right?
My lord, I will beg to differ with that, my lord, because my lord, the documents show that first it was sold, the transfer, there has been a transfer of property in goods.
Correct.
Then there has been a lease by CFL to this petitioner.
Correct.
Particular period, my lord.
Correct.
So it's not a tripartite thing.
No, he's not even saying it's tripartite.
My lord, first it was transferred. Then CFL has leased it to the petitioner for a particular period.
Right.
So, my lord, by showing all these things, what I beg to point out that at the contemporary period, the parties have intended it to be a goods and not to be a immovable property. And that, my lord, would also find at no point of time, either before the assessing officer, before the appellate authority, or while filing the appeal before the tribunal, the petitioner has ever contended that it's an immovable property. It is only while filing this revision, he has annexed a 2005 document, which my learned senior has read out that certificate. That's a 2005 document pursuant to order of the tribunal. Now he is contending that it's an immovable property.
No, not correct.
So the intention at that point of time till disposal of the appeal before the tribunal was it's a movable property, and accordingly the petitioner has never raised this contention that it's an immovable property. So this is my first contention. Thereafter, my lord, may I just point out that the definition of immovable property. Now, my lord has seen that attached to earth, immovable property is defined under, my lord, section 326 of the General Clauses Act. It says that, my lord, just may I place that definition?
Yes.
Immovable, section 3, subsection 26 of the General Clauses Act. Its immovable properties shall include land, benefits to arise out of land, and things attached to the earth or permanently fastened to anything attached to the earth. So what now my learned senior is saying, it is embedded to a concrete structure. So it basically comes around attached to earth. Now attached to earth has also been defined under the General Clauses Act. If my lord, it will be easier if my lord, I have given a citation to handed over to the postmaster 2010. There it has been elaborated. If I can the lordship to that 2010 volume 5 SEC. I have also given to my learned senior.
Yes.
My lord, may turn to page 129. 129 of that.
Yes.
Paragraph 22.
Yes.
There section 326 has been quoted. Then paragraph 23. Then may I turn to paragraph 24. The definition of attached to earth. Paragraph.
That is again the Central Excise Act, I think, right?
Yes, my lord.
All right.
There, attached to earth, quoted that attached to earth means paragraph 24.
Right.
Rooted in the earth as in the case of trees or shrubs, embedded in the earth as in the case of walls or buildings, or attached to what is so embedded for the permanent beneficial enjoyment of that to which it is attached. Then paragraph 25 may I place. It is written from the above expression, attached to earth has three distinct dimensions. One, rooted in the earth as in the case of trees or shrubs. B, embedded in the earth as in the case of walls or buildings, or attached to what is embedded or for the permanent beneficial enjoyment of that to which it is attached. Attachment of the plant in question with the help of nuts and bolts, as in the case of the petitioner. Foundation not more than 1.5 feet deep, intended to provide stability to the working of the plant and prevent vibration, wobble, free operation, does not qualify for being described as attached to earth under any of the three clauses extracted above. That is because attachment of the plant to the foundation is not comparable or synonymous to trees and shrubs rooted in the earth. It is also not synonymous to embedding in earth of the plant as in the case of walls or buildings, for the obvious reason that buildings embedded in the earth in permanent and cannot be detached without demolition. Embedding of a wall in the earth is also in no way comparable to attachment of a plant to a foundation meant only to provide stability to the plant, especially because the attachment is not permanent and what is attached can be easily detached from the foundation. So also the attachment of the plant to the foundation at which it rests does not fall in the third category, for an attachment to fall in that category, it must be for permanent, this is important, permanent beneficial enjoyment of that to which the plant is attached. It is
No, so that's the whole point. So can you, if you remove any element of this furnace, can you still use it as a furnace, blast furnace?
Well, it is
you cannot. If you have to run it as a furnace, if you dismantle any part of it, you cannot use it as a blast furnace.
Well, it is only attached to the concrete structure by knots.
No, if that attachment is removed, you can never use it as a blast furnace. The whole idea of a blast furnace is there are several components to it, including the brick lining, the concrete base, all of that.
That is attached to that oven, and that oven is attached by a knots and
That's right. So even if you remove just the oven, you can't use it as a blast furnace. If you remove the concrete and bricks, you can't use it as a blast furnace.
But my lord, that is how it has been, the market rate of it has been fixed and sold. Of the individual parts, the market rate has been determined parties and it has been sold to the CFL, my lord.
All right.
So, my lord, this is my next. One more judgment may I place, my lord?
Yes, yes.
98 volume 1 SEC that I have.
Moment. I'll just note this down. 2010.
It's my lord, 2010 volume 5 SEC page 122.
And the next one is
1998 volume 1 SEC page 400.
All right.
Paragraph 5. May I place just for that?
Yes, yes.
Paragraph 5, the right side D below, the test is,
yes, yes.
The test is whether the paper making machine can be sold in the market. The tribunal has found as a fact that it can be sold. Here in the present case, it has been sold. In view of that finding, we are unable to uphold the contention of the appellant that the machine must be treated as part of the immovable property of the company. Just because a plant and machinery are fixed in the earth for better functioning, it does not automatically become an immovable property.
So the Sirpur was considered in Duncan.
Yes.
Which Mr. Sahu read out.
Yes,
that Duncan has also been considered in the 2010 judgment, which I have.
Yes.
Yes,
and then 2010 is considered later in some other judgment.
I will reply.
No, but the basic principle is, like you're correctly pointing out, intention of the parties. That is definitely one criteria is intention of the parties.
And what has fallen from your lordship also, that has been read in paragraph 6 of that 98, my lord. May I read that?
Yes, yes.
A further argument was made that the entire machinery as it is cannot be bought and sold because the machinery will have to be dismantled before being sold.
Correct.
Tribunal has pointed out that the appellant had himself bought several items and completed the machinery. It had purchased a large number of components and fabricated a few and manufacture the paper making machine at site. If it is sold, sold it as it has to be dismantled.
That's the key line there. Correct. That's the key line.
So
that is exactly what I'm telling you. Suppose he had sold it to Capital, and Capital intended as a result of the sale to dismantle it and then take it somewhere else and assemble it. You could still argue that he was actually selling those individual components.
But my lord, here for business considerations, he has purchased it and has leased out it for his business.
Which means there was no intention to dismantle at all.
No, my lord, intention is he has leased it out for a particular period. For a period of, now he has not purchased the property, the land of it. He has only purchased.
Sorry, 1 minute, please. Yes, please.
Yes, madam. Now, my lord, this judgment says if it has to be dismantled here and reassembled at another place, then
correct. So that's not the case here at all.
Here, my lord,
it's nobody's case. They're going to do that.
But my lord, here he has leased it out to the petitioner for a particular period. Now he has not purchased the land of it. He has only purchased the plant part of it. He has leased it out for a period of 2 to 3 years with a renewable clause. But here, my lord, may kindly take into consideration the lease period is over. Then, my lord, it has to be dismantled, and he has.
We can't. Now you're trying to add facts which don't arise. You have to. You're looking at a transaction when it occurred, right? All right.
But the issue of the judgment, if it has to be.
We'll reserve orders. We'll reserve orders. It's a very interesting question. All right.
Yes, sir. May I just refer to few other judgments which I have given to lordships, and in that judgment, it has referred to in the circular at page 13 of today's Lord's compendium.
Right.
That's in that.
Ibex Gallagher.
My lords. Paragraph E at page 13. That after Supreme Court judgment, Supreme Court has also referred to this. If items assembled or erected at site attached by foundation to earth cannot be dismantled without substantial damage to its components and thus cannot be reassembled, then the item would not be considered as movable and will therefore not be exchanged.
Right, right.
And this is also followed along with several other judgments.
All right, all right.
I have given paragraphs also which I refer to.
All right, all right. So orders reserved in all three matters.
The other two, you also could see. Other two, there we have the CFL, the purchaser hearing, assessee there in those two cases. There, what the department has done, the department has charged tax on the transfer of the right to use the goods.
Right.
Use that plant and machinery to the petitioner hearing.
Yeah, yeah.
The transaction, which my lord,
it can't be sales tax anyway. So
once it is immovable, it cannot be released out. Goes out of purview of entry 54 minutes.
All right, all right.
And 2010 judgment, your lordship refer to para 39, 40, 41, 42, and 44, which my learned friend has not pointed to your lordship. That is in my favor.
All right.
The ultimate finding, yes,
right.
Obliged, much obliged.
Item number 15. Item number 15.
May I please, your lordship? May I please, your lordship? During this case, my lord,
you able to hear him?
the petitioner has filed.
Are you able to hear him?
Are you able to hear us?
Yes, whether I am audible or not.
But you are not able to, but we are not able to hear you because you have to speak to the mic.
May I please, your lordship? Hearing this case, my lord, the petitioner had filed this writ petition challenging the award by annexure 3 at turning page 11 to 15, my lord. Passed by the OP number 2, my lord. With a prayer that the order dated 15/12/2011 by annexure 3 by the opposite party number 2 will not be declared illegal, arbitration will not be quashed, by the petitioner will not be given an opportunity of hearing before passing an order by annexure 3, keeping in view the circumstances mentioned above. Fact of the case is like this, my lord. This judgment of the OP number 1 was appointed as a DLR basis, my lord, on 2/10/88, my lord, as a lighter, my lord. While he was continuing as such, he died on 29/6/2000, right, my lord, which will clarify from annexure 1, my lord, at page 9, my lord. Got it, my lord? Udayanath Sahu on 29/6/2000, my lord. He died, my lord. After his death, then the son of the Udayanath Sahu applied for paid for appointment, my lord. But by that time, my lord, he has also took the shelter of this honorable court. Honorable court directed to consider, my lord. But due to his minority and all other things, my lord, this OP number 1 was appointed on DLR basis, my lord. But due to certain reasons, my lords, he was also not allowed to continue. On 17/6/2009, against that termination order, she took the shelter of the tribunal, my lord, height and OP number 2. Before the honorable tribunal, I kindly see what please she has taken, my lord, may kindly see.
the award by Annexure 3 at page 12, my lord. What stand she has taken saying that she has been appointed on rehabilitation assistance scheme, my lord. Got it, my lord? At page 12, my lord.
Carry on.
My lord. At page 12, my lord.
Carry on.
Yes, my lord. Page 12, my lord. May I place, my lord? In her claim statement, the second party has asserted that consequent upon death of her husband in an accident in course of his employment under the first party, she was given employment under rehabilitation assistance scheme. On 1/8/2000, she joined to work as a peon in the establishment of the first party. She had filed one claim case for payment of a compensation under the Workmen's Compensation Act. In that case, the commissioner under the Workmen's Compensation Act passed an ex parte award for payment of a sum of rupees 1,81,370 towards compensation to the family of the deceased. When the first party did not implement the award, the compensation authority attached the property of the first party. Being aggrieved with the said action, the first party denied employment to the second party with effect from 17/6/2009 without complying with the statutory provisions.
So come to para 5.
Para 5, not so much. Para 5, my lord. The averments made in the claim statement are not refuted by the first party who opted not to contest the claim by filing written statement. The sworn testimony of the second party cannot be discarded on any ground.
So what is your answer to this?
Yes, my lord. I have categorically said that though the executive officer, these and executive officer appeared, but due to cancer, he could not participate, for which he died. In 2012, my lord, I have categorically mentioned in my writ petition, my lord, may kindly see para 11 at page running from page 5, my lord. May I place, my lord?
Sir, the date of this award is 15th December 2011.
Yes, my lord.
When were you given notice in this?
Then thereafter we got the notice, my lord.
This reference itself would have been made under notice to you, correct?
Yes, my lord.
That is 13th May 2010.
Yes, my lord.
So nothing prevented you from filing written statement.
Yes, my lord. By that time, the then executive officer affected in cancer. He had
1 minute, please. Cancer and all happened later. It is not as if only one person in this entire establishment will file a reply.
Yes, my lord. I'm coming, my lord. I'm coming, my lord. He had not disclosed anything else to any officers.
We are not concerned with all that, please. This is not an individual. This is an office.
Yes, ma'am.
Yes.
To that extent,
in fact, this kind of filing a writ petition, the name of individual itself is erroneous. I don't know why you have done this.
One thing, another thing is
look at the cost title in the award.
My lord.
Come to page 11. Your writ petition should not even have been registered like this.
My lord.
What is the cost title?
The management of executive officer NAC Nilagiri, my lord.
How will you file this writ petition? Look at the cost title of this writ petition.
My writ petition is that Ashok Kumar,
1 minute. Where is this Ashok Kumar Mahapatra in the award cost title?
That by that time.
So you can do whatever you like.
The executive officer.
1 minute, please.
My lord, when he came to know.
Are you able to understand our point?
My lord is saying that.
Are you able to understand the question, Mr. Misra?
My lord, your lordship is saying.
Mr. Misra,
my lord.
Are you able to understand our question?
This person was not there. Your lordship posing a question to me.
No.
My lord.
The award, the contest is between the workman and the management. The management is the NAC.
My lord.
Are you the NAC?
The executive officer is representing to that NAC.
But you are Mr. Ashok Kumar Mahapatra, not executive officer.
As the executive officer in the NAC.
That cannot be. You know, Mr. Misra, how a NAC has to be represented.
That correct.
Not by you. It has to be represented by the executive officer or NAC. How could you personally represent the NAC?
The executive officer, as an executive officer, he had filed this petition.
You have not. Are you not able to write?
Sir,
1 minute. 1 minute, please.
Yes, my lord. Executive officer.
Sir, you don't seem to have the patience.
Okay.
You don't seem to have the patience to listen to judges at all.
Sorry to that the mention is wrong to that extent, my lord. I am admitting, my lord, that mention is itself wrong, my lord. I am admitting, my lord. I am admitting, I am not disputing to that extent, my lord, that mention itself.
What else? Carry on. What else do you have to argue?
So far the reverse that has to be mentioned, my lord, but wrongly it has been mentioned.
Okay. After 5 minutes, you finally realized it. It's all right. What is your explanation for not filing any reply to the claim?
This is this thing that I did an executive officer though appeared, but she did not disclose anything else to the authorities. So that's why it creates a problem for clearly I am admitting.
Anything else? Anything else?
Yes, madam, to that extent. Another thing is that the person concerned before this honorable court was able to file such a petition counter saying that the husband was appointed on a permanent basis, my lord, making a false statement before this honorable court in the counter which has been filed, my lord. Her husband was appointed on DLR basis, my lord. Now making a statement before this honorable in the counter, may kindly see that the first attack of my rejoinder, my lord, where from he got and making such a statement, her husband was appointed on permanent basis.
You forget about the pleadings here. Let us go by the pleadings in the labor court.
Yes,
there are no pleadings from your side.
Yes, madam.
And you have no explanation for that except to say that officer got cancer much later and died much later after the award. Yes.
Another thing with respect to that extent, when a person saying that I have been appointed rehabilitation assistance scheme, how it is applicable to a DLR employee? Making a false statement got the award.
Where is your pleading before the tribunal?
No, I was not. I have that's why.
Then what you have not pleaded before the tribunal?
That's
how could you take this question before this court?
No, that creates a problem, my lord. That's
no. You tell us the law.
I'm not disputing that. I'm from
so everything you are not disputing, but continuing to argue.
From the very inception, I am saying this is the difficulty. I were not filing counter. That doesn't mean that taking advantage of that, she will say whatever on that basis. He will be that petition will be allowed, my lord.
Right.
To that extent, my lord, the reported decision of our Supreme Court, my lord, by saying on the statement that cannot be accepted. 2006 Supreme Court 56, my lord.
In absence of pleading.
No,
from the side of management.
No. So far as my contention is that mere saying that I have been appointed rehabilitation assistance scheme cannot be accepted unless only the relevant documents have not been produced before the tribunal, my lord.
All right.
May I place my lord that relevant portion of
all right. Read it.
My lord.
Do you have copies for us, sir?
My lord.
We are not entitled to copies.
My lord.
All right. Please read it.
My lord, sorry, not audible.
Do you dispute Exhibit 1?
Yes, my lord. Yes, that's why.
Do you dispute Exhibit 1?
So for Exhibit 1 is concerned, my lord.
Produced before the tribunal.
Yes, my lord.
He doesn't even understand the question.
So far DLR is concerned, I am not disputing, my lord.
No, you are not disputing.
DLR is concerned, I am not disputing.
That's right.
So far the claim before the tribunal saying that I have been appointed on rehabilitation assistance scheme, that is my dispute, my lord.
All right.
The rehabilitation assistance scheme only applicable to the permanent employees.
All right.
And moreover, what she has said before this honorable court in 2001, her husband has been irregular. That is not correct at all. I have mentioned in my petition, if your lordship permit me to place, even if it has been referred to the government denied, my lord. Where from he got all those things has also placed before this honorable court in counter, my lord. To that extent, I want to, if your lordship permit me to that extent, to clarify to what extent he come to this honorable court with a clean hand to get justice, even before the tribunal, my lord. Keeping with the decision of all the decisions of Supreme Court and also the decision of this honorable court. To that extent, a person has to come to, even if the tribunal, come with a clean hand to get justice. Because it is admitted fact, I have not appeared. I am not disputing from the very inception, my lord. That doesn't mean a person will come forward and whatever he will say, that will be accepted and will be carried out, my lord. That is my sole contention. So you come to clean hand with you have no right to suppress all those things before either the tribunal or before this. Rather, before this honorable court, my lord, to what extent he has trying to mislead this honorable court by filing counter. To that extent, I want to know only thing. I admit and bound on before lordships that I have not filed the counter. I have not get an opportunity because of the death of the person concept that from the very inception I have said, my lord. That doesn't mean taking advantage of that. You will do whatever, you will make submission and to get an order from the tribunal. So this will be the precedent for all other persons who are continuing on DLR basis. They will say that is the DL on the basis of rehabilitation that person has got the benefits.
That workman has been reinstated now.
No, that
No, stay.
no, that will not be.
You got to stay here for the asking. Day one stay. Yes, who's for the other side?
Yes, ma'am. Well, can you see the page 32, my lord, that the resolution of the council, my lord.
Yes.
At page running page 32, my lord. It has been stated that, my lord, the sixth line below, my lord, municipality dhara 1953 रो 432 এবং 433 ও সাধারণ
What
প্রশাসন
are you saying? Are you concerned?
Odia.
Are you concerned that my lord is understanding your?
Like, I have not given the.
So you have to
It has
say in
stated-
translated version, not to read like the in this.
It has been stated that he has given Anuja is Sau is the OP number 1, the wife of the OP number 1 has given a rehabilitation appointment under the rehabilitation scheme. Mila. That has been stated in the resolution passed by the on 22nd July 2000. Mila.
All right. You will write the judgment. So you will write the judgment. Yes. Yes, please.
Yes. The second, my lord, they have admitted that they have got the notice, they have appeared, but they did not contest the case and did not also file a so-called, my lord. The sufficient opportunity has given, my lord. I have rendered near about 8 years service, my lord. I have given appointment on, I have joined in service on 1/8/2000, and they have retained me on 17/6/2009, my lord. Near about 8 years I have service without giving any notice and without giving complying the mandatory provision of section 25F. They have retrenched me, my lord. The land tribunal has rightly and rightly held that the retrenchment of the petitioner OP number 1 is illegal, and they directed to reinstate the OP number 1 with the full back with just, my lord.
All right. Yes, anything else?
Extent the counter which has been filed by the opposite party want to draw your lordship's attention only 2 to 3 paras, my lord. But they have said, my lord. Counter affidavit, internal page 4, my lord, para 4, my lord. First I want to draw. Got it, my lord?
Carry on, carry on.
The averments made in para 4 of the repetition are not correct as regards that the husband of the Upanimar Udayanath Sahu was working as a DLR employee as a lighter electrical conductor. Committed that the husband of the Upanimar working as a permanent employee, my lord. Simultaneously, my lord. Now, before this honorable question, permanent employee as a lighter under the petition. Then thereafter, my lord, I kindly see next.
Do 1 minute. 1 minute.
My lord.
Yes, the other side. Do you have the copy of the evidence affidavit filed by you before the tribunal?
No copy with my
Evidence affidavit that you filed before the London tribunal.
yes, no copy with me, my lord.
All right.
Next, para 10, my lord, at page 5, my lord. That the fact, may I please, my lord? That the facts stated in the petition are not correct. The husband of this opposite party was appointed on 2/10/88 and the post was regularized by the government HR Department of Hyde, letter number so-and-so, letter so-and-so, HR 28/1/94. It is further submitted the OP number was not appointed backdoor method, my lord. So then thereafter, may I kindly see page 6, my lord. Of that para, page 6, my lord. May I place from the top, 5th line, whereas there are as many as the posts lying vacant in the office of the petitioner, but vindictively they have terminated this opposite party from her job, my lord. To that extent, my lord, I have filed in my read petition, I have a categorical state, my lord.
All right, we have
Page 4, my lord. Page 4, my lord. Page 4.
All right, we have heard both of you.
All right, orders reserved.
The another point while I'm giving decision, my lord. The plea of the petition is that since the OP number 1 was a DLR employee, question of prior notice and given reason for termination does not arise, my lord. The Supreme Court has honorably stated that even if it is a part-time or contractual on fixed wages or casual employees, comes under the definition of workman, my lord. And the mandatory provision of the section 25 of the ID Act is required to be complied, my lord.
All right, next.
One thing with the lordship's permission, if he is a permanent employee, what is the attractive of a 25F? As per her statement that I am a permanent employee. So question of attracting ID Act does not arise at all.
Item number 16.
I am appearing for opposite party workman.
Just after this. Who's for the petitioner? Anyone for the petitioner?
Your Lordships, I am for the petitioner, Your Lordships.
Yes.
Your Lordships, actually, we have not got any instructions from the client since long time. We have written a letter and all that. So
All right.
we will
Counsel, the petitioner states that despite writing letters, no instructions are forthcoming from the petitioner. The petitioner is dismissed for non-prosecution. The interim order earlier passed and vacated. Yes.
Item number 17.
We'll continue after lunch.
Milords, may I just mention, Milords, item 36 is specially fixed at 2 p.m. Mr. Sibal is in Pathad, Milords. So may I requesting to, instead of 2, he's requesting to take it up at 3 p.m. Milords, item 36, Milord.
That may not be convenient. So we'll have to fix another date. You mentioned it at 2 o'clock.
Malaj,
Yes, Mr. Sibal.
Malaj, I'm sorry, Malaj. I never thought that this parted would continue from 11 o'clock to now, Malaj. I'm still on.
Okay. No, whichever date will suit you, because today.
27th is all right, Malaj? 27th is a Monday?
No, not this one, Mr. Sibal. That, because it's all tied up. I've got some other matters on that day.
Then
it will have to go after the vacation now, because it's going to be very, very tight now.
After
We
vacation,
could have
means
it on
what?
27th October if you're okay.
Oh, that's too far, Malaj.
No, I can't help it, Mr. Sibal, because there are 2 full weeks of vacation for puja.
Give me just 2 hours before, Malaj.
It's really not possible. I'm trying, because every day we've got half an hour of mentioning, and I'm trying to adjust a large number of matters.
Well, so the question is, it's a 15 crore day per loss. It's my fault, Malaj, that I'm not here today. But it wouldn't have finished anyway, Malaj, today.
That's
the whole
right.
thing.
That's right. So 27th, we'll definitely fix it for 27th.
Of October.
Yes. It will have to go there.
All right. Okay, what can
We'll
I
listen. 2 o'clock on 27th. Right.
All right.
Milord, can I mention item 30?
Yes.
Milord, we got a counter recently. I need to file a rejoinder, and then the matter can be set down for hearing. If my lord could kindly have it on any convenient date.
All right. Item 30, you say, Mr. Jain states that he would like, the petitioner will file a rejoinder within 4 weeks.
Malaj, we appear for respondent number 1, Malaj. We have filed a counter affidavit, Malaj. May I just only pray that a short date may be fixed, Malaj? Reason being, there's a order operating whereby the respondent number 1 commission is not permitted to pass a final order, Malaj.
I know.
So any short date, short date that is convenient.
3rd November.
Lord, the interim order may continue.
Yeah, interim order to continue.
Deeply grateful.
I am present to mention my lord, item number 20. The pleadings may be urgent to next week, my lord. Because I have little difficulty because one of my item is there in court number 3, my lord.
No, which is item
Compassionate
number?
appointment. Item number 20, my lord.
Item number
20.
20.
Who's for the other side? Who's for the other side?
Other side is minus the tax department ITU. And
there must be some other side to you.
Who is the lawyer appearing for the other side?
and Mr. Udgata and Mr. Siddharth Mahapatra. I've already informed them.
All right, counsel, the petitioner states that he's in some personal difficulty, list after 12 weeks. All right.
Obliged, madam.
Item number 17.
Lords, item 5 was passed over to 2 o'clock.
Yes.
Pass over item number 5.
Please, your Lordship. Lords, this is an application for bail filed for appellants numbers 4 and 5.
Correct.
Who are in custody since 21st of January 2013, Lords.
Yes.
Lords, at the outset, I'll draw your Lordship's attention to Annexure A, which was proved through the IOPW 26, wherein he has admitted that there are no criminal antecedents against any of the appellants, including the petitioner.
Yes.
Now, so far as these two petitioners are concerned, Lords, they have not been implicated at all in the trial through any direct or any circumstantial evidence also whatsoever. The only material appearing against them is the so-called evidence relating to confession and discovery of a tabli made by the appellant number 2, Milords, which is marked as Exhibit 9, is signed by the IO on 23rd of January 2013, but from the records, it appears that appellant number 2 was arrested on 27th of January 2013. And this statement has been made in the presence of two witnesses. One is PW 7 and the other is PW 19. So they have deposed, my lords, that when the confession leading to discovery was made by the IO, by this appellant number 2, he has implicated these two appellants as being part of the conspiracy and being members who had accompanied the other appellants in the Xylo vehicle. The entire case here, my lords, rests on circumstantial evidence. The circumstances which the prosecution sought to prove, my lords, are that firstly there was a conspiracy. And this conspiracy was sought to be proved through witnesses who have turned hostile and have not supported the prosecution story. They are PWs 3 and 4 and PWs 9 and 10. The second circumstance on which the prosecution relied on is the last seen theory. That has been sought to be established through the evidence of PW 11, who has deposed that he has seen the appellant number 3 and the deceased going together in the night prior to the occurrence. He also does not speak about the present appellants 4 and 5. Now, the third material on which the prosecution relies is the statement leading to recovery of appellant number 2 under section 27 made before PWs 7 and 19, and which they have deposed, my lords. But the statement itself shows that it has been signed by the IO on 23rd of January, though the appellant was arrested on 27th of January, and specific questions have been put to the IO PW 26, where he has also admitted, my lords, at paragraph 41, he has admitted that he has put the date 23rd of January 2013 under his signature in that statement, which he has said was an inadvertent mistake.
Right.
And of the 26 witnesses who have been examined, including 8 witnesses to the inquest, this is the first time I see, my lords, 8 inquest witnesses having been examined. No one has implicated these two appellants in any manner whatsoever, including any of the other witnesses.
Okay. Yes, who's for the Mr. Katkia?
No, my lord, I'm appearing for the state.
Yes, Ms. Patnaik.
Yes, my lord. What I do partially agree with what my learned senior says, my lord, that none of the witnesses have implicated these two accused persons, my lord. Nevertheless, how they have come into the picture is, my lord, by leading to discovery. My lord, here the chain of circumstances has been proved by the prosecution in the sense a previous motive was there. There was a altercation preceding that. There was a last seen theory, and there was a leading to discovery. It is during this leading to discovery, my lord, that this one of the main accused, they have given a detailed description of how they have executed the plan, the conspiracy, my lord.
All that is not admissible, Ms. Patnaik, you know that.
That is, I am conscious of that, my lord. That's what your statement discovery. Otherwise, my lord, I do agree that it is a case of circumstantial evidence, and these two persons have not been named by any of the
there is no. He started by saying there are no criminal antecedents.
That part, you know, that part.
That is the exhibit A, your lordship can see evidence of PW 26.
All right.
That part, I'm sorry, my lord, I will need to go through, my lord.
Yes.
But there was a conspiracy, and these people were a part of the conspiracy, my lord, and leading to discovery, my lord. If you can segregate the two, admission and the leading to discovery, my lord, the fact leading to discovery, my lord, the conspiracy is definitely related to the fact, my lord. The part that there was a conspiracy and these people were sitting in the Xylo, which dashed against this person, my lord.
Yes.
And with
In that
regard to the xylomyloids, there is Exhibit B, that is the report of the DFSL Balangir Mylods, where they have stated that no incriminating materials were found on the seat of the xylo which was sent.
Because the xylo was taken to the garage and it was repaired, and unfortunately the garage person has also
No, madam, you are wrong. The MVI's report shows that the xylo had some marks of accident. There was no repairs done. And the garage owner has been examined. He has also turned hostile and he has not supported the prosecution.
And regarding the part that my lord, that my learned senior says that he was arrested, and before that date, my lord, that has been discussed by the learned court below, it was an inadvertent mistake on part of the...
It's a costly inadvertent mistake.
Date is not a...
It's a very costly mistake.
This is an application. This is Miss Case number 515 of 2018. This is an application for bail on behalf of appellants 4 and 5. That is Adi alias Adikanda Sahu.
Adi Millers.
Adi, that's it. Appellant number 4 and Juvaraj Boy, appellant number 5. In the case arising out of Sessions case number 47/24/11 of 2013. Full stop. Along with 3 other co-accused, these 2 appellants were convicted by the Sessions Court by the judgment and order of conviction dated 21st February 2018 for the offences punishable under sections 302 read with 34 IPC and 120 capital B read with 34 IPC, and were sentenced to undergo imprisonment for life and to fine of rupees 25,000 each, and in default to undergo RI for 6 months each for both sets of offences. Paragraph. It is stated that both these appellants have been in custody since 22nd January and 21st January 2013 respectively. Paragraph. Mr. Panda, learned counsel appearing for the appellants at the outset, points out that as has emerged in the deposition of the investigating officer bracket IO bracket PW 26, neither of these appellants have any criminal antecedents. Full stop. Paragraph. He points out that this is a case based on circumstantial evidence, and as far as these 2 appellants are concerned, the only evidence against them is in the form of a statement made by appellant number 2 purportedly
under section 27.
Under section 27 of the Indian Evidence Act. He points out that even this appears to be doubtful since the statement was purportedly made on 23rd January 2013, whereas the said appellant number 2 was shown to have been arrested on 26th January. 27 January 2013. Full stop. The other, the evidence is in the form of further he points out that the statement was to the effect that these 2 appellants were seen along with, were along with the other accused in a xylo vehicle. But even after the vehicle was seized, no blood stains were found therein. No blood stains or any other incriminating piece of evidence was found in the vehicle. Paragraph. Learned Ms. Patnaik, learned additional government advocate, points out that the complete chain of circumstances was proved by the prosecution. Stop. She, however, did not contest the submission that the only piece of evidence vis-a-vis these 2 appellants
was the so-called statement made by the co-accused.
Appellant 2.
Appellant number 2, paragraph. Having considered the above submissions and without expressing any final view at this stage, the court is of the view that both these appellants have made out a case for being enlarged on bail at this stage. It is seen that both of them have been in custody for over 8 years, and it is unlikely that the present appeal will be taken up for hearing in the immediate future. Stop. For the aforementioned reasons, both these appellants, that is appellant number 4, Adi, alias Adikanda Sahu, and Jubraj Bhoi, are directed to be enlarged on bail during the pendency of the appeal, subject to terms and conditions to be incorporated in the order of the trial court.
Lords, may I be pardoned? May I be pardoned?
Yes.
Both these appellants were arrested on 21st.
I see, because the application says 22nd and 21st.
I'm sorry, my lords. They were arrested. There is one other thing I'd like to point out. Probably the charge is under 120B read with 34, but as your lordship knows, 120B presupposes more than one person. Correct. So read with 34, my lords, should not have been.
That's right.
Along with that. So that read with 34, your lordship may omit from the order.
All right.
Much obliged.
All right. The application is disposed.
Item number 17.
Leave of your lordship. May I submit my notes? This is a case, my lords.
It's the additional affidavit, my lord, senior is relying upon, which I received on 20th of September. I have to respond to that. Only day before yesterday I have received. And I have not, also I pray for responding to the rejoinder.
All right. There's an additional affidavit filed by the petitioner on 20th September, is it?
Yes,
2021, which is not come on record. Which has not come on record before us.
I was told the affidavit was before your
It
lordship.
be placed on record. Mr. Sahu states that he would like to respond thereto. He is permitted to file a further affidavit in response to both the said affidavit as well as the rejoined affidavit within 4 weeks. Just after 8 weeks.
Item number 18.
May I please, your lordship, my lordship. This is I am for the petitioner, my lord. Pleadings are complete, my lord. Your lordship, see the input order, the petitioner's challenge, the order of the collector Bhadrak, Annex 4 at page 36. Lordship, turn to page 38, last portion, my lord. In fact, Lordship, got it, my lord?
Yes.
38. In fact, the plot number 207 government land identified by the revenue inspector Chandigarh is a gochar land, and there is no excess gochar land in the vicinity. Similarly, the area 12 decimals of plot number 2580 gifted for construction of Kodabarua Gram Panchayat office is a Ghorabari scheme of land having all sorts of locations, advantages, and completely suitable for functioning of Gram Panchayat office, Kodabarua. This is my challenge, my lord. The Kodabarua Gram Panchayat is a newly constituted Gram Panchayat, my lord. They need minimum 40 decimals of land for the construction of Gram Panchayat house and the all other buildings regarding quarters, my lord. Therefore, as per the direction of the collector, a land of 40 decimals was identified by the Tahsildar through the RI, my lord. Now, some other person, the Sarpanch interested to construct the Gram Panchayat building in his own village. Therefore, he got a portion of the land, 12 decimals gifted through a person, my lord. That is accepted by the collector, saying that there is no excess of gochar land, my lord. Now, a lordship is my rejoinder, my lord. A rejoinder. In rejoinder, the report, my lord, says, my lord, the entire Gram Panchayat, there are excess gochar land of 33 acres.
It's all disputed question of fact.
These
Please, we
are
can't
all-
get into these things.
Your rejoinder will never go beyond the collector's affidavit. Your
Correct.
lordship may kindly see the Tahsildar has made the affidavit.
Yes.
He wants that on Gochara land, our GP office should be established. And the collector's view is that no, we will not go on
No,
Gochara land because
we-
there is no excess. And this is a factual dispute.
Madam, the land requires minimum 50 decimals,
He is
my
a
lord.
general public,
50
your lordship, this is a PIL. And we have decided that we will construct the GP office on a recorded land, Ghoravadi status, and in favor of the government. He is insisting that it should be over a Gochar land. The collector's view in the impugned order is that no, over Gochar land, I will not allow the construction because there is no excess
collector
land.
says there is no excess gochar land.
Yes, that even if there is no excess, if the administrative authority are not interested, if the administrative authority is not interested to establish the office over a Gochar land, how as a public you can insist the government that a collector now you, this is very peculiar, and for last 2 years he is not allowing.
I am for the interest of the Gram Panchayat, my lord. The Gram Panchayat
No,
needs
who are you?
minimum 40 decimals. Minimum
I don't
40 decimals
understand
land
how
is
you
what-
are competent to say that where the office will be located.
No,
The
not
collector has
that,
decided that it will be over a private recorded land of this Gram Panchayat, and you are insisting that it should be
All
over
right.
a Gochar land.
All
The
right.
yes.
All right, this is the second round of litigation concerning the proposal of the opposite parties to construct a Gram Panchayat office over a piece of land in village Koda Barua in police station Bhadrak, district Bhadrak. Initially, these very petitioners had filed writ petition civil 6079 of 2018, which was disposed of with this court on 18th April 2018, with the direction to the collector Bhadrak to dispose of their representation within 3 months from the date of the receipt of the order. Paragraph. Pursuant thereto, the petitioners were heard, and on 30th April 2018, a reasoned order has been passed by the collector Bhadrak, negativing the plea of the petitioners that the
GP office,
GP
cannot-
office should not be located
Yes.
at the proposed site. Paragraph. The operative portion of the order, based on the verification with the Tahsildar Bhadrak, reads as under that in fact the plot number 207,
in fact,
from that up to the end stands disposed of. This is in annexure 4, pages 38 and 39. Paragraph. Then it concerns the petitioner referred to the rejoined affidavit filed, where it is sought to be contended that there is in fact sufficient land available in the vicinity for the GP office.
No, my lord. He is saying that there is sufficient land of Gochar Kisam.
That's right. Sufficient Gochar land available for the construction of the GP office there. Full stop. Apart from the fact that this appears to be a disputed question, the fact remains that the collector was not in favor of the GP office coming up on a Gochar land.
Yes.
Full stop. The determination by the collector that the land in question is Gharabari Kisam, having locational advantage and suitable for the functioning of the GP office, cannot be disputed, questioned at this stage. Full stop. The collector was basing his view on the report submitted by the Tahsildar, and there is no means of there is no occasion for this court to doubt its correctness. Full stop. For all the aforementioned reasons, the court finds no reason, no ground made out for interference with the impugned order of the collector. The writ petition is dismissed. The interim order stands vacated.
Item number 19.
May I please, my lords? This writ appeal is filed by the university.
in the writ appeal, the order dated 25th February 2021 is challenged. In the writ petition that was decided 14858 of 2006.
He wanted the benefit of pay and allowance applicable to the post of manager for 9 days, 22nd March to 31st March 2011.
The question is, I have filed a petition also specifying the provisions which have not been taken into consideration by my lord, the single judge.
No, what is the effect of giving him this benefit for 9 days? What will happen?
It is, my lord, he filed the application on the very day. He was a grade 1 assistant. He was given additional charge of the guest house because the guest house manager was not there. It was given for 5 days, from 22nd to 26th. On the very day of 22nd, he filed 2 applications. One for resignation and another for his promotion. That was by mistake taken into consideration by the register, the vice chancellor also, and that order was taken. It was kept in abeyance on 25th. So he subsequently filed the respondent has appeared in the case and filed a petition that
there has been no stay of the order. What have you done in the meanwhile?
No stay. Stay doesn't work. Stay. No stay. No stay, my lord. Your lordship can dispose of the matter. Very short matter. I have.
Have you implemented the order or not?
My lord? Implementing the order, my lord. Implement the order, but that's why I have challenged it.
No, you have challenged it. There's no stay by this court. There's an order of October 2020.
269, statute 269 doesn't permit such provisions. But your lordship may see the order. Admittedly, the petitioner doesn't have the requisite qualification to hold the post of manager Utkal University Guest House. But this is the order of the my lord Justice, Honorable Justice.
But challenge is 9 days and all of that. Why are you challenging this such a small relief granted?
How can it be granted promotion for 9 days and that too resignation to be accepted on the very day of his application when he will be retiring on 31st March 2011. Will be retiring. He has retired on 31st March 11, but filed an application for resignation. For resignation cannot be accepted that way, my lord. 269 is very clear in that. Statute 269 is very clear in that matter. I am placing before my lord. Notwithstanding anything contained in statute 268, an employee may retire voluntarily from service anytime after completing 30 years of...
Notice is not gone in this appeal yet.
Madam?
There's no notice issued in this appeal yet.
He was retiring on the...
No. Mr. Jena, are you appearing?
Yes, ma'am. He has appeared.
I have also filed a short counter and also my lawyer senior has filed an application. I have given him application for incorporating some provision. I have also filed objection to that.
All right.
Yes.
In that case, not further time.
Mr. Mahanti, kindly answer what is the effect of this 9 days promotional order? financial effect.
But cannot be given the promotion. Retired and promotion both can be taken up today, one day. He cannot retire unless he's given a prior notice. For 9 days, how can we promote it for 9 days only when such is not allowed?
No, what is the financial effect?
Financial effect, a lot of financial effect.
What is it? Lot of financial effect? What is it?
Manager, he has no qualification.
No, what is the financial effect you're not telling us?
Financial effect, my lord, I can submit if I get from the office.
No, why are you pursuing in such
financial effect?
We'll just leave this question of law open.
How much?
We'll say the facts and circumstances. He's 70 years old now. Why do you want to chase him now?
But financial effect, it's a university.
The retirement took place in 2011, no?
Retired 31st.
10 years now.
So leaving the question open for the
we won't interfere in these kind of matters. Yeah.
Second, he submit. Like you see the peculiarity. File the application for promotion.
All peculiarity. This is also even more peculiar. Filing an appeal for this kind of a matter. You say the present appeal by the Utkal University is directed against an order dated 25th February 2020 passed with a single judge, allowing writ petition civil 14858 of 2016 filed by the respondent and directing that the university will pay to the respondent the salary attached to the post of manager of Utkal University Guest House in terms of the appointment order dated 22nd March 2011 till the date of his retirement as such, that is 31st March 2011, and that the pay of the respondent should be fixed and consequential post-retirement benefits is revised accordingly. Paragraph. Having heard learned counsel of the parties, the court is of the view that the impugned order, which grants the benefit of the pay and allowances for the short period of 9 days when the petitioner worked as manager of Utkal University Guest House, does not require to be interfered with in the peculiar facts and circumstances of the case. The court notes that the appellant is now well over 70 years old and the monetary benefits that he might get in the form of post-retirement benefits are not so substantial as to warrant interference at this stage. Nevertheless, the court clarifies that the impugned order will not constitute a precedent, and the questions of law raised by the appellant are left open for decision in some other appropriate case. The appeal is accordingly discussed.
Item number 21.
The order may be worked out within a stipulated time. I don't know, kindly indicate because.
No, why? You go for you implementing the order of the single judge, you go before this.
Yes.
My lord, I will file rejoinder affidavit in this case.
Item 20 has been adjourned, minutes.
Yes, I want adjournment. Matter relating to one-time cash assistance in lieu of employment.
Item 20 has been adjourned, minutes.
21, my lord.
20 has been adjourned.
Abatements.
Yes, item 21.
Yes, my lord, I will file rejoinder affidavit. Already NTP filed counter affidavit. And your lordship will call it after 3 weeks. In the meantime, I will file rejoinder affidavit.
Opposite party number 3. Who is opposite party number 3?
I'm appearing for opposite party number 3 and 4.
On behalf of NTP, man.
Have you filed your reply?
I have filed my reply.
Only Asha, you filed a reply. What's the matter about? Okay, counsel the petitioner seeks and is granted 4 weeks time to file a rejoinder. List after 12 weeks.
My name may be recorded for opposite pact number 3 and 4.
All right.
Item number 22.
So may I please, my lords? This is my case. That's why the petitioner has provided service bills to opposite party number 5 bills. That's the instance of one of the creditors, because he has moved before the NCLT and the NCLT
You do not wish to file any rejoinder?
Yes, I have filed bills. I have filed. Copy has already been sought bills.
No, rejoinder is not come on record. When did you file it?
Let's see if the rejoinder has been filed.
Because I think it might not have been brought. I have given yesterday.
No,
it's
not
court master bills. Court is the court master.
Now he's
We have to file the counter the rejoinder affidavit. Your lordship,
this matter is now fully covered by the judgment of Honorable Bombay High Court. Mr. Mishra, my lords, your lordship, I have no grievance against him. So I have no grievance against him. I don't have anything to argue against him. So therefore, my friend may refrain from.
Then your prayer is instructive.
I have no prayer against. I will rather. No. I am going to amend now with my lord's permission.
Exactly.
That is a mistake I have committed. Instead of 2 and 4 bills, your lordship may permit me to rectify to 3 bills. That is why Mr. Mishra is now.
Exactly.
Yes, I know. I understand. That 2 and 4 may be read as annexure opinion number 3 bills. I have only grievance against opinion number 3. This is a case bills. No, just I am submitting. This is a case bills. I have wanted bills. There is only one judgment I could find directly on the point, which is by Honorable Bombay High Court. I have given a copy of the judgment to your lordship bills.
Where is that?
This is the short case of the petitioner, which your lordship will kindly appreciate. Where the learned NCLT, where I raised bill supposing bills on 1,000 rupees. Because that one of this creditor, operational creditor, went to Honorable learned NCLT. Learned NCLT with the approval of committee of creditors settled my dues at 20.5%. Because all the operational creditors, their dues are settled at 20.5%. Matter went to NCLT and finally rested before the Honorable Apex Court bills. I have annexed a copy of Honorable Apex Court judgment, right? Annexure bills, Annexure 4, Annexure 3 at page 60 bills. At page 60, it starts from page 60. My lords may only see one paragraph at page 89. That will suffice the purpose, minutes. Page 89, paragraph 103 minutes.
Yes.
The appeals filed by the Committee of Creditors of SR Steel Limited and civil appeals are allowed. The impugned NCLAT judgment is set aside, except in so far as civil appeal number 640/2009, 19 civil appeal number civil concerned, which are dismissed. In so far as civil appeal of 666 of 19 civil appeal concerned, the appeals are partially allowed in terms of judgment. The writ petitions are disposed of in terms of the judgment. It is made clear that the CIRP of the corporate debtor in this case will take place in accordance with the resolution plan of ArcelorMittal dated 23/10/2018 as amended and accepted by the Committee of Creditors on 27/3/2019 as it has provided for amounts to pay to different classes of creditors by following section 32 and regulation 38 of the code. Now, next page, I have given the list of approved creditors, which is approved by the Committee of Creditors, Annexure 4, and must then finds place at page 99, serial number 754. Page 99, Jagat Janani Services, 754. It's a small letter. I will pray your lordship to kindly bear with because these are all in tabular form.
No, in our
754.
In our monitor, we can expand it quite comfortably.
Minus. So
the advantage of.
Absolutely correct. So 754 Jagat Janani Services, INR 8.
No,
serial number 754.
754.
754 Jagat Janani Services. The petition before lordship now.
Correct. Jagat Janani Services.
Minus. Correct. 18 crores, 14 lakhs, 03,469. This is the amount. Now, I will be getting, instead of this amount, which is the amount of services I have provided, only 20.5%. That comes to 3.71 crores. Plus, I have paid tax on the entire value of 18 crores.
Right.
Now, after the honorable judgment of Supreme Court, the amount which is now payable as consideration by the operational creditor is reduced to 3 crores 71. Honorable Bombay High Court said, when the consideration as per the IBC code is adjudicated as a lesser amount, the tax will be payable on that because I have not got the money. I have to pay otherwise on 100%. So accordingly, Honorable Bombay High Court said that to the extent now the money is payable by the creditor in respect of the service are provided, now the tax is payable accordingly and balance will refunded. Now, my lords, the lordship kindly see. I am taking your lordship's attention to judgment of the Honorable Bombay High Court. I have given a copy to my lordship.
Yes, yes.
That's para 39. Internal page 31, para 39 years.
Yes.
Following the above, we have no hesitation to hold that once a resolution plan is approved by the Committee of Creditors by the requisite percentage of voting and the same is thereafter sanctioned by the adjudicating authority, the same is binding on all the stakeholders, including the operational creditors. As a matter of fact, respondents herein as an operational creditor had lost its claim before the resolution professional. The resolution plan provides for settlement of service tax dues at 5% of the amount of principal dues that will be crystallized upon adjudication, further providing for waiver of interest, penalty that will be charged. As you have held above, respondent may be justified in proceeding with the so-called demand notice because that has resulted in crystallization of the total amount of service tax dues, that is the principal amount payable by crystallized as above. The resolution plan says that the same will be settled at 5% of the principal dues adjudicated. In my case, it is 20.5%. Right. The word used is adjudicated and not adjusted, as sought to be read and applied to the respondent. Thereafter, the amount that the petitioner will require to pay 5% of rupees so and so. In so far as the recovered amount is 6.23 crores is concerned, the same is part of the total demand determined. After remaining 5% of so and so, respondent is duty bound to refund the balance amount to petitioner, which will not only be in terms of resolution plan and thus in accordance with law, but will also be a step in the right direction for revival of the petitioner.
All right. All right. Mr. Sahu, let's ask Mr. Mishra.
Mr. He did respond.
Your Lordship may kindly turn to the prayer. Your Lordship may kindly turn to the prayer.
Yes.
Prayer I have to amend. I don't have anything else against you.
Let me complete. Let me exonerate myself.
No, I don't have any grievance against you. No grievance at all.
Mr. Mishra, if that it's a highly technical point, we are going to record at the outset that he has a grievance only in the opposite party 3.
Exactly, correct.
My Lord, then your Lordship, the major amount against opposite party number 2 and 4. And pursuant to the rejoinder filed by the petitioner, he has no grievance against that amount of 12 crores, your Lordship. Your Lordship, that my respectful submission, that I want to draw your Lordship's kind attention.
No, so we are granting relief only vis-a-vis respondent number 3.
Absolutely.
Your Lordship, then I have nothing to say. Then I have nothing to say, your Lordship.
Para 40 also, your Lordship may kindly consider because that refers to a full bench judgment of Bombay High Court, where it has been said that under 226 Constitution of India, writ application lies for enforcing the obligation of the state to refund and to return money collected was illegal. So these are there.
All right.
May I please, Your Lordship?
Yes.
I appear for respondent opposite part number 5 and 7, my lords. My learned senior has made a submission that he is restricting his prayer only to opposite part number 3, my lords.
Correct.
And I have already filed my counter. A rejoinder to that effect has also been filed, where they admit my stand in the counters.
Okay.
My lord, in the opposite part, he has to file the rejoinder affidavit, which is essential. Some documents are to be filed. So I am appearing on the opposite on 3, my lord. Some documents should file, so I have to file the rejoinder affidavit to the counter affidavit, my lord.
No, how can you rejoinder to the counter? I don't understand. He has already filed rejoinder to your counter.
I replied to lord. I replied to the gentleman.
Your appearance will reflect, yes. The present petition.
Yes, sir. I will pardon one point, Milords. There's opposite party number 5 and 7. They have also given the response by filing a counter, and they have admitted that this 20.5% of 18 crores, which I am supposed to get from them, they have not even paid that. They said that your Lordship kindly see, it pays 5 of the counter.
Mr. Sahu, you said you are confining your prayer only against opposite party number 3.
Minus.
No, prayer is only for 2 and 4, my lord.
No, that is.
That I am correcting. That I am correcting. With my Lord's permission, I am correcting. Yes. But 5 and 7 on their own, your Lordship kindly see for a moment, 5 and 7 counter and pays 5 years. Only one para, your Lordship will find. Page 5, paragraph G, small g.
Yes.
Yes, sir. During CIRP in terms of approved resolution plan, the petitioner is operational creditor of erstwhile DSIL was found entitled to receive an amount of rupees 3,71,087 against admitted claim of 18 crores, so and so, a fact admitted in para 9 of the application. The aforesaid amount was tendered for deposit on 16/12/2019 by you of RTGS in the petitioner's industrial bank account by the UTR number so and so. The payment was intended to the petitioner in terms of approved resolution plan. And
We'll note this. Yeah, we'll only note this.
Because they have not paid. They said that
they have now provided in their rejoinder for the first time a fresh account. We have said once you have give us a new account number, we will do it. They have now for the first time the rejoinder said so. Given as an account.
I have given now. I have already given now.
Yeah, so he'll deposit it, he says.
Minus.
We'll do it and give us some time, then we'll do it.
All right.
Minus.
Because their account was freezed.
Your Lordship kindly reflect that he has no grievance against the 1,92 lakhs.
Yes, please. Yes.
Because that he has represented so far as the refund of 1,92 lakhs.
All right.
Yes, and no grievance against opposite partner 5 and 7.
All right. The petitioner has filed this writ petition challenging the realization of service tax / GST by opposite parties and seeks the relief of refund in the circumstances explained in the petition. Paragraph. At the outset, Mr. Jagavindra Sahul and its senior counsel for the petitioner clarifies that there is a typographical error in prayers B and small d and small e of the
D and E. D and E.
Yeah. Where in place of single quotes opposite party number 2 and 4 unquote, it should read as open quotation opposite party number 3 unquote. Full stop. In other words, he clarifies that he has no grievance against opposite parties 2 and 4. And the prayers in those prayer clauses are in effect against opposite party number 3. Instead of the said clarification is taken on record. Paragraph. In view of the above clarification, Mr. Mishra, appearing for opposite parties number 2 and 4, states that he has no further submissions to make. Paragraph. Further, as far as opposite parties number 5 and 7 are concerned, it has now been clarified by them in the counter affidavit filed on their behalf in para 5 small g as under. Just reproduce whole of G paragraph. In the rejoinder filed by the petitioner to the above counter affidavit, the petitioner has set out the present account number of the petitioner.
8 of the rejoinder.
Sorry?
My apologies, my lord. Para 8 of the rejoinder.
Para 8 of the rejoinder. Paragraph. Counsel appearing on behalf of opposite parties 5 and 7 clarifies that since the petitioner has now indicated its present account number, opposite parties 5 and 7 would credit to the said account the admitted amount as stated in para 5G of the counter affidavit. In view of the above clarification, Mr. Sahu states that he has no further grievance as far as opposite parties 5 and 7 are concerned. It is directed that the above payment be made not later than 4 weeks from today. Paragraph. As regards the prayer against opposite party number 3, the background facts are that the petitioner is a registered partnership firm which was registered under the Finance Act 1994, and after coming into force of the Orissa GST and Central GST Act 2017, has also obtained GST registration under the said statute. Full stop. It is stated that the petitioner was raising invoices from time to time, charging service tax prior to 1st July 2017 and GST after that date for various services rendered by it to opposite party number 5. Full stop. It was stated that against various services for which invoices were raised by the petitioner during the period January to December 2017, opposite party number 5 had not paid a sum of rupees 2142.70 161.00. It is stated that opposite party number 5 had availed of the input tax credit in respect of the above sum in the input credit ledger maintained by it. Paragraph.
You interrupted. They have reversed now. They have filed counter.
They have already reversed it, my lord.
They have
Okay.
reversed now.
It has now been clarified in the counter filed by opposite party number 5 that this entry of ITC has been reversed in the ledger. Paragraph. The operational creditors as well as some other creditors of opposite party number 5 filed applications before the National Company Law Tribunal, bracket NCLT, Ahmedabad, under the Insolvency and Bankruptcy Code 2016, bracket IBC, in CP bracket IB numbers 39 and 40 of 2017. Full stop. By an order dated 8 March 2019, the NCLT Ahmedabad concluded the corporate insolvency resolution process, bracket CIRP, approving the resolution plan submitted by ArcelorMittal India Private Limited, bracket opposite party number 7, in terms of section 31, bracket 1, IBC. The operative portion of the said order of the NCLT reads as under. Take from page 8, the quoted portion. Paragraph. An appeal was filed against the above order before the National Company Law Appellate Tribunal, bracket NCLAT. Full stop. By a judgment dated 4th July 2019, the NCLT disposed of the said appeal, filed by one of the creditors, and held that cases where the adjudicating authority or NCLAT could not decide the claim on merits, such appellants would be allowed to raise the issue before the appropriate forum in terms of section 60, bracket 6 of the IBC. Full stop. Paragraph. Arising from the above order of the NCLAT, the Committee of Creditors of SR Steel India Limited, bracket opposite party number 8, filed civil appeal numbers 8766-7767 of 2019 in the Supreme Court of India. By its judgment dated 15th November 2019, the Supreme Court disposed of the aforementioned appeal, set aside the judgment of the NCLAT, and held that the CIRP of the corporate debtor would be in accordance with the resolution plan of opposite party number 8, as amended and accepted by the Committee of Creditors on 27 March 2019. Paragraph. Opposite party number 7. In terms of the said resolution plan, and as per the excerpt of the list of operational creditors
bracket which has been enclosed as Annexure 4 in the present petition. The name of the present petitioner occurs at serial number 754. Full stop. As against the amount of rupees 21,42,70,161, comma, the admitted sum payable by opposite party number 5 was indicated as 18,14,03,659. Full stop. Pursuant to the decision of the Supreme Court, the claim of the petitioner was to be settled at 20.5% of the total claim, that is 20.5% of the aforementioned sum of rupees 18,14,03,659. Paragraph. The case of the petitioner is that it has already paid towards service tax rupees 69,07,696 and towards GST rupees 192,66,932 for the aforementioned period January to December 2017. It accordingly admits that there has to be a pro rata reduction of the liability, since it is to get only 20.5% of the outstanding amount. Full stop. This works out to rupees 371,87,750. And the tax payable works out approximately to rupees 45 lakhs. Full stop. The petitioner accordingly has calculated the excess to be excess tax paid as rupees 2.16 crores approximately, and claims this is a refund from opposite party number 3.
I'm sorry, Your Lordship. Your Lordship, I'm sorry. Your Lordship, that 1,92 lakhs is the tax paid towards GST. Only so far the refund is, Your Lordship, he has no grievance against that GST payment. Only grievance is pre-GST period. The payment of pre-GST service tax, Your Lordship. So 1,92 lakhs, he has no grievance.
No grievance. That's only Your Lordship said 69 lakhs. That may be corrected as 1,49,12,429. That has been affirmed by opposite party of 5 in counter affidavit page 7 belongs, because that is the correct amount. Page 7.
He has admitted that he has no grievance. That amount has been paid and input tax credit has been taken by that.
There is no grievance. I also admit. Because that 69 lakhs Your Lordship said, that should have been 1 crore per page 7 of the counter of OP number 5 pillars. They have mentioned the correct amount.
Page
7 of the counter by OP number 5 and 7.
In the counter affidavit of OP number 5 and 7, it is clarified that
last para.
The sum payable to the petitioner, that the
But this is the reversal amount, which we have already reversed.
Yes, reverse GST, not this is reversed.
Service tax. I'm sorry.
Yes, that has gone to government account now. We will get refund.
That is what I'm trying to tell.
GST amount has been paid, Your Lordship.
Yes, madam.
The service tax amount that has been paid is rupees 141,12,429.94.
Yes.
It has been reversed, my lord.
And the credit taken in this regard has now been reversed. So how much is refundable to the petitioner now?
So, Miller, that is to be calculated, because 20 service tax payable on 3.71 crores will be calculated, and that payable amount will be adjusted against 1 crore 41 and balance to be refunded.
All right. It's clarified by Mr. Sahu that now the refund will have to be calculated on the basis of the service tax calculated, on the service tax on the sum payable to the petitioner against its admitted claims, and refund will also have to be calculated on that basis.
20.5% also be clarified.
Right. Paragraph. It is seen that in similar circumstances, one of the creditors had approached the High Court of Bombay, the Bombay High Court. One of the creditors of opposite party number 5, that is GGS Infrastructure Private Limited, had approached the Bombay High Court in WPLDVC number 268 of 2020. In a judgment dated 22nd December 2020, the Bombay High Court observed as under on the facts of that case. Let's take para 39. It is seen that the Bombay High Court took note of the judgment of the Supreme Court in Committee of Creditors of Essar Steel India Limited.
Yeah, just small interruption. He is not opposite number 5. That's a different case, Minos. Similar case, Minos. OP number 5 was not bad.
That was not an Essar Steel case, is it?
No matters, no matters.
I see. A similar case, you see. Paragraph. Consequently, the writ petition is allowed and a direction is issued to opposite party number 3 to calculate and pay to the petitioner the refund of the excess service tax paid by it, by acknowledging that the petitioner is entitled to receive only 20.5% of the admitted claim amount, which works out to rupees 371,87,750, right?
Right.
The excess service tax so calculated will be refunded to the petitioner in accordance with the extant rules within a period of 8 weeks from today. The petition is disposed of in the above terms.
Item number 23.
Dear my lord, I am received counter today, my lord. Some time to be given, file a rejoinder, my lord. I am for the petition.
All right. Petitioner seeks to file a rejoinder, seeks and is granted 4 weeks time to file a rejoinder, placed after 12 weeks.
Item 24.
In this case, I am for the petitioner. It's a pension matter. No counter has been filed as yet by the government.
Who's for the?
I am for the statement. We have already filed counter.
No, we have not received it. He's also not received it.
17/9/2021.
Not received. You say the counter affidavit stated have been filed by the respondents, opposite parties on 17th September 2021, be served on counsel of the petitioner and also be brought in record. Rejoinder be filed within 4 weeks, rest after 8 weeks.
Item number 25.
My lord, in this case, opposite party 2, 3, and 4, they are necessary parties. They have not given a counter since 9 months.
My lord, this is regarding a policy by State Bank regarding
regarding
empanelment of valuers, my lord.
Right.
The policy has been framed by the State Bank, my lord, and State Bank. I have filed on behalf of State Bank. I have filed my counter, my lord.
When?
Yes, they have.
On 30th June, my lord, I have filed.
But 2, 3, and 4.
I have received the counter of the SBI, but the party, the finance secretary is the party number 2, the RBI is the party number 3, and Indian Banks Association party number 4. They are the necessary parties because their orders have been violated by the bank.
Who's appearing for 2, 3, and 4?
Yes,
Mr. Padi, you are appearing for 2 and 3.
There are no counter till date, man.
No, but who's appearing for 2 and 3?
We have given the party a copy. I have given to the party.
No, Mr. Bharat,
since 9 months.
Anyone appearing for 2, 3, and 4?
No state. No.
Mr. Padi is entered appearance for Union of India.
My lord,
Who's appearing?
My lord, CK Pradhan, my lord.
So you have to file your reply.
2 weeks time after instruction.
Final opportunity is granted to the opposite parties 2, 3, and 4 to file their respective replies within 4 weeks. Rejoinder to all the affidavits be filed within 4 weeks thereafter. List after 12 weeks.
Item number 26.
Yeah. Oh, ADs from 2, 3, and 4 not received. ADs were not received from 2, 3, and 4.
They're a very necessary party because their orders have been violated by the.
All right, we say fresh notice to opposite party number 4 by registered speed post, returnable in 4 weeks. All right. The tracking report be placed in the call. Then the same order. All right. Yes.
Item number 26.
Let the opposite parties have not filed the counter affidavit. They are asking for time.
Okay. Final opportunity to the opposite party to file reply within 8 weeks. Rejoinder within 4 weeks thereafter. List after 12 weeks.
Item number 27.
My lord, may it please, my lord. I am appearing for the petitioner in this case. This is a case of export of iron ore fines, my lord. Before the impugned order, which has been challenged in the writ petition, is at page 68, my lord.
How long will this take?
Pardon me, madam.
Take some time. We'll list it for final hearing one of these days. We say list for final hearing after 12 weeks. Pleadings are complete. Right.
Item number 28.
Yes, sir. But in the last hearing, my lords were kind enough to ask the question that despite the repeal of 1994, how can it be shown that the respondents or the appellants, my lords, they were conscious of the fact that the 1994 was repealed and still they have taken a decision?
You're not audible at all, Mr. Tripathi. Your mic is not good.
Am I audible now?
Not very well. I think you have to speak into the mic, or I don't know what that is.
No. Well, the question put to me in the last hearing was that despite repeal of 1994, it has to be shown that the appellants were indeed conscious that the 1994, notwithstanding the repeal, was sought to be given. Well, to make good that they were conscious, I will invite my lord's attention to 2 facets. One, that not only, my lord, they have given 1994 after the repeal to series of cases, but even after the decision taken by the Principal Secretary on 13th of August 2013, there are documents to indicate that the government consistently
The last order is not scanned.
Whereas the government consistently believed that this is a case of 1994.
You see the last order.
My lord, on the last order, your lordships had asked me to look into their documents. So let my learned friend finish.
We'll have to take it at the end of the board. Let's finish the board and then come back to this.
Lordship pleases.
See this is the last order. Right? You see that? You will not find it in the digital file. In the digital file, 15 September order is not there. We'll take it at the end of the board. Yes.
Item number 29.
May I please, Your
Yes, my lord. I am appearing for the petition in this matter.
Yes, I request the learned senior counsel to argue the case. It's a matter related to installation of PET-CT scan matter. Learned senior counsel is on virtual mode.
Yes, madam. On the last occasion, the lordship had
Before Mr. Acharya begins, can I make a small submission? I am for the Acharya Harrier Cancer Center, my lords.
Yes.
In response to a rejoinder filed by the Maitri Sansad, that is the letter petitioner,
Yes.
I am filing a reply, my lords, there too. Today, my lords, let that be taken on record. I have served copies on Mr. Ajay Mahanti and I have served it electronically on Mr. Sahu for the state.
You also served on Mr. Acharya?
Yes, copy has been served on Mr. Budhia today by my
clerk. All right.
Today I have received a lunch hour, my lord.
All right. You say the reply filed by the Acharya Harihar Institute to the letter of Maitri Sansad be placed on record. Copies thereof have been served to the other parties. When should we keep this? After the puja vacation?
May I submit one thing, my lord?
By then, probably, my lords, even that PET set scan will also have been installed.
All right, good, good. Please do that.
May I submit one thing, my lord?
Yes.
No, as I have got one submission to make, my lord.
Yes.
I had raised certain allegations or rather negligence on the part of the Acharya Harrier Center while treating this petitioner who ultimately succumbed to her death, my lord.
Right.
So now they have also filed a reply rejoinder. So at least that part can be taken up today, my lord, because that's a separate aspect altogether. It has got nothing to do with PET CT scan.
Mr. Acharya, one thing is, I don't mind doing that, but we may have to wait and we'll have to see because we may not be able to. I can't sit for long today. I have a meeting at 4:15.
Okay.
All right.
Then we have it on the next date, man.
Yes.
Obliged.
We'll take it up on 11th November.
Obliged, my lord.
One small prayer, my lord. A report was called for from the AIMS regarding from the nuclear department. Last occasion, the government requests the AIMS and copy also served to Mr. Pari that to report be called for regarding the feasibility of the installation of PET in two places, as Barampur and the Baleswar, because only department available in Orissa is the AIMS only, my lord, nuclear department.
Yes, Mr. Sahu.
The nuclear medicine department of AIMS have not responded to our query. Well, I'll pursue that. I'll pursue that. Whatever state has sought for.
All right. All right.
May I pray, my lord? I would like to file a reply.
You use the mic, please. There is a mic that side.
My lord. Sorry, my lord. I am appearing for Maitri Sansad, my lord, letter petitioner. Today I have received the reply from OP number 3. I would like to file a reply.
Go ahead and do that.
You
go ahead and do that.
My lord.
Yes.
Oblige, my lord.
Item number 31.
I am appearing here for the private opposite party.
Who's for the petitioner? So none appears for the petitioner.
Sorry, my lord. I am for the petitioner, my lord. I am for the petitioner, my lord.
Yes.
I want some time to file rejoinder to the counters.
All right. Rejoinder be filed within 4 weeks. List after 12 weeks. All right.
Item 32.
May it please your lordship.
Yeah.
My lord, in pursuance to your lordship's last direction, the Union of India is yet to file the affidavit. The state has filed some affidavit yesterday and today. I am also going through it. Let the Union of India also file it with regard to the transponder issue and all those.
Yes. Who's for the Union of India, Mr. Pari?
My lord, CK Pradhan, my lord.
CK Pradhan, please file your affidavit.
Yes, ma'am.
Yes.
For
on many of the issues highlighted in the earlier orders, including the issue of transponders, the court would like the Union of India to file an affidavit indicating its stand within 4 weeks from today, with an advance copy to the amicus curiae. List on 16th November.
Item number 33.
Yes, my lord. Item number 33, my lord. I am for the petitioner, my lord. In item number 33, your lordship, I am for the petitioner, my lord.
Yes.
Petitioner challenges the demolition of shop room stall number 6 at Badambari bus stand, your lordship. And his
subsequent eviction, therefore, despite his subsisting license and restraint orders passed by this honorable court in WPC number 25 of 2018 and 2059 of 2020, my lord, wherein possession has been protected, my lord, by this honorable court. Besides, as a street vendor, my lord, the petitioner seeks rehabilitation in the existing shop room, which are available in Badambadi bus stand as per the mandate of Street Vendors Act 2014 and the scheme framed thereunder, my lord. My lord, petitioner even has been craving out his livelihood, my lord, more than 30 years as a street vendors in the Cuttack's bus stand at Badambadi.
Have they filed the reply?
No, my lord. My lord, I am for the opposite party. Their licenses, I had filed a miscase that there is an arbitration clause. To that, they have not filed any reply. They have filed certain affidavit miscases.
There is a Supreme Court. There is a Supreme Court judgment is that in that regard, my lord.
1 minute, Mr. Mishra. You are appearing for the OSRTC.
Yes, ma'am.
You're not filing a reply.
State copy.
My lord, the repetition, if your lordship will see the
Filing any
notice.
counter affidavit regarding
My
this.
lord, no notice has gone. My lord, may kindly see.
No, 4th
Connected
March
matter was, we have not got, we have not got copy.
Or did you serve a copy? You say Mr.
My
Mishra.
petition copy has already been served. This matter has already been listed before the old court building, court number 2, where my learned senior has appeared.
And not in this matter. Copy, then we'll have to ask him to apply and get a copy from the court.
In the
I will supply, my lord. I will supply the writ application copy. I will supply, my lord.
All right. Another copy of the writ petition be served on Mr. Mishra appearing for the OSRTC. The replies be filed within 8 weeks, within 4 weeks.
May I clarify? In the first writ application, we have received copy, but in the connected matters, if your lordship will see, there he did not file requisites. We have not received copies. In the connected matters.
All right, in the connected matters. Also to Mr. Monty,
in connected matters.
Replies in all petitions be filed within 8 weeks, rejoinder within 4 weeks thereafter. List up to 12 weeks.
My lord, may I submit, my lord, one thing? In the connected matters, the orders of the Honorable High Court has already been annexed in the writ application. These applications were order of the single bench, your lordship. That order, that annexures.
Kindly see the notice.
I don't want to waste time on these details, but kindly read the cause list. You don't seem to have filed requisites in those writ petitions for service of notice on the opposite parties. Kindly do the needful and carry on now. Otherwise, the matters are going to get indefinitely delayed. Yes.
Item number 34.
In item 34, yesterday only I have been served with a copy of the counter at 2 p.m. I need some time to file a rejoinder. The state has filed a counter adverse to my
all right. Rejoinder be filed within 4 weeks. List up to 12 weeks.
But, I have also not served with a copy of that state counter.
All right. Copy of the counter will be served on consular other parties as well.
Number 7, 8, and 9.
All right.
One more thing I was praying for your lordship's kind consideration. The entire case is based on one VPA case, one Bebondos case. With your lordship's kind permission, may I file the petition copy of which I have given to the state as well as to the endowment council? Of course, my learned senior, I have not been able to serve a copy. Those two records may be called for, the state can produce it. That I am praying for. That is the only thing that will decide the entire issue. With your lordship's kind permission, may I present the petition,
Let the matter be hard.
It's a mistake.
Next day you can give us all that. Yes.
Yes, sir. I am presenting the miscase, your lordship, let it be on record.
All right.
Ma'am, obliged.
Item number 35.
All right. I've said it should be served on everybody. All right.
Your lordship, I have filed the counter. Your lordship, I am appearing on behalf of opposite party number 8 and 9. I have already filed the counter and I have served the counter.
Notice to opposite party number 10 has been returned undelivered.
Oh, my lord. 8 and 9 I have filed.
Who's for the petitioner? Mr. Harichandran? None appears for the petitioner. In the interest of justice, list up to 12 weeks.
You say fresh notice be issued to opposite party number 10 after the current present address is furnished by the petitioner at the registry within 1 week.
I have given the corporate address. I am permitted to.
All right.
Item number 37.
May I please, Your Lordships?
Your Lordship, item number 37, Your Lordship, pursuant to Your Lordship's earlier direction, we have made the fixed deposit, and Your Lordship, I have already submitted that fixed deposit copy, Your Lordship. And Your Lordship, I am permitted to file counter.
Right, counter be filed within 8 weeks, rejoinder within 4 weeks thereafter.
Obliged.
Obliged, Judge.
List after 12 weeks. Right.
Item number 38.
Dear Lordship, pursuant to your Lordship direction, we have served copies on all the opposite parties. We are yet to receive a reply or counter affidavit from anyone.
Replies be filed within 8 weeks, rejoinder within 4 weeks thereafter. List after 12 weeks. Right.
Item number 39.
Please, Your Lordship. Lordship, kindly see order dated 7th of July 2021. Lordship issued notice and directed the opposite parties to file counter. No counter affidavit till date has been filed. And this is
yes, Mr. Mahapatra. Where is Mr. Mahapatra?
Am I audible, my lord?
Yes, file your replies, please.
My lord, instruction has not been received, my lord.
All right, replies be filed within 8 weeks, rejoinder within 4 weeks thereafter, interim orders to continue. List after 12 weeks.
My lord, only one thing, that assessment records they have to produce.
Yeah, that's already there. Yes.
No, it's not there, my lord.
All right, the assessment records we produced on the next date. Yes.
Item number 40.
My lord, I am appearing for the petitioner. Counter copy filed by the government 1 to 4.
You have to speak louder, please.
I am received yesterday.
He has received the counter copy yesterday. Yes. He wants some time to file return.
2 weeks time to file return.
I appear for the opposite party number 5, my lords. On the last occasion, the opposite party number 5 has misled this court and taken a status quo order, my lords. They have misled the court and they have stated that the IMFL shop is not operating till date. So for that purpose, we have moved an interim application which is numbered as 1350540. It may not be before your lordships right now. So therefore, let it be placed tomorrow, my lord, so that we could place on record various documents which could indicate that the IMFL shop is open. And
no, my lord, what has happened, my lord? After the interim order of status quo was passed, by recording the submission of the petitioner that the shop is running. Yes. Soon after that order is passed, in the very next day, I have filed an affidavit on behalf of the superintendent of excise, explaining inter alia that this shop was running in running condition prior to the status quo order, and that affidavit is on record. So this the status quo order was on the basis of the submission of the learned counsel for the petitioner.
That was an incorrect
submission. So he is no way prejudiced the opposite party. The shop is running, and the status quo order is.
Yes, status quo means if you are running, you continue to run.
Yes, that is what I am saying. So there is no necessity to list the matter soon.
That's right. All right. Rejoin to be filed within 4 weeks. What is your application number?
13540, my lords.
13540 of 2021. It's taken on board. Notice is accepted by the non-applicants. Replies, if any, be filed to this application within 4 weeks. Rejoin before the next date.
Grateful.
List after 12 weeks.
Item number 41. 4.
May I please, my lords?
Today we may not have time for this, Mr. Sahu.
Sorry, my lords.
We may not have time for this today.
Your lordship may keep it to a short date, any date your lordship.
All right. All right. List on 26th October.
My lords.
All right.
So list of citation I have filed may be kept on record.
All right.
In my lord, in any event, he has already finished his quota today.
All right.
My lord, my appearance may be recorded.
Yes, yes.
Obliged.
Item number 45.
My lord, I am for petitioner in item number 45.
Yes.
My lord, this is a matter which has been pending for quite a long time, my lord. So I have prepared a brief synopsis of facts and because so many rejoinder encounters have been filed. So a brief synopsis and a short list of dates have been prepared, which will be submitted in a course of day or two. My lord, I have challenged the order of the High Court giving me compulsory retirement in this matter. So, my lord, I was an officer.
We'll take it on board and we'll hear it on some other day. Because today I have to have a meeting on the administrative side. I can't sit beyond 4 o'clock today. All right.
My lord, keep it on some other day, but my lord, keep it on Tuesday or Wednesday.
All right.
My lord, that is my humble request, my lord.
23rd November. List on 23rd November.
My lord, it's Tuesday or Wednesday, my lord.
Yes.
Item number 46.
Obliged, my lord.
May I please? Madam, this matter relates to the interjudgeship transfer of a senior stenographer, and this matter is squarely covered by the judgment passed by this honorable court in Narayan Mishra versus State of Orissa. Your lordship kindly have a glance at the order of 25th 7, 2019. This has been observed by the in view of the decisions of this court dated 7/11/2017 in the matter of Narayan Mishra and the State of Orissa and others. Passed in WBC number, the above read petition is admitted. And I have given the earlier I have given and given the.
You do not wish to file any rejoinder.
My prayer is it may not be necessary.
All right. Counsel, if the petitioner states rejoinder is not necessary, the pleadings are complete. List for hearing on 24th November. All right.
Item number 47.
You lordship may call this matter any other day.
All right. At the request of counsel for the petitioner, list on 8th December.
Pass over. Item number 28.
I was submitting my lord to my lord's question last time. Since 1994 repealed on 2013, how can we establish that they were?
Mr. Tripathi, I think you're not getting a good computer in your desktop in your office.
It's a new one.
Get a state of the art. You can afford it, Mr. Tripathi.
No, that's right, my lord. But it's a new one. I don't know why I'm experiencing the difficulty. Lord, next time I'll fix it. Now, my lord, the question put to me.
Mr. Sangal.
Yes, my lord.
Can you hear him clearly? We are not able to hear him clearly.
You can't hear me, my lord?
No. Can you hear Mr. Tripathi? We are not able to hear him clearly.
No, my lord, it breaks. His voice is breaking up all the time. I think he's too near the mic. We should
That's
go
what.
back.
Okay, Manad, I'm making a little distance now. Now, Manad, the question that was put to me last time was that admittedly 1994 stood repeal as of 2013. 2013 was the year when the decision was taken to grant me 1994.
He's moving his head or something happening. I don't know what's happening.
Now, how can we establish that the appellants have taken the decision to grant me 1994 as a conscious decision? The fact that it was a conscious...
Mr. Parija?
My lord, we can have it some other day.
No. Are you able to hear? Is it really us, sir?
My lord, Mr. Tripathi's voice is breaking. Probably is a new system.
It's all because of you, Mr. Parija.
I'm so sorry, my lord.
You're making him nervous, or you're making sure his mic doesn't work well.
Yes.
My lord is far away in Delhi.
Precisely for that reason, last time I came down to have a physical hearing.
I know.
No, no, I'll just make a little attempt on that. Now, the question that was put to me was that how can you establish that they were conscious in taking their decision in giving me 1994? Now, that would be answered on three facets. One, now the first answer would be that the appellants have given 1994 grant.
You are not audible.
I'm not audible.
Clear, at all clear.
But I'll fix it, kindly have it day after tomorrow.
Mr. Tripathi, we are going to compel you to come down to Cuttack now. After all, you are from here.
But that's a great privilege to go there and see my lords there physically.
When can we have it? You tell us, give us a date.
But day after tomorrow?
No, not so soon. Our board is super heavy.
No, my lord has already heard it almost fully, except that another 15-20 minutes will be taken, my lord, to complete it. Because there is a stay operating against me.
I know that.
That's
Mr. Sangal will also, I think, address. He is also in this.
My lord, I'll take about 20 minutes, not more.
All right. I think you take a chance on 29th.
29th, sir.
All right. 29th at 2 p.m.
My lord, can we have it on 30th? 29th, I'm stuck in.
All right. 30th at 2 p.m. 30th.
Lordship pleases.
All right. Stop the live stream.